Please rise. Justice of the Appellate Division, Supreme Court, First Department. Hear, hear, all persons having business with the Appellate Division, draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department, and Happy New Year, since it's my first time on the bench in 2025. Most of you know how this works. I'm going to proceed with the call of the calendar. Please ask for the time that you absolutely need for your arguments, not the time that you want. Understanding we have 6.5 hours of argument time requested. If I granted all of your time, we'd be here into the wee hours of the night. Okay, so, and please know, as I try to tell everyone before they get upset that I've cut their time, the clock is for you, not for the court. So if my colleagues are so intrigued by your brilliant arguments that they have more questions, I let them go, okay? All right. People versus Leston Anderson. Submit. Deutsche Bank versus Marino. Submit. D. Adekunle is a submit. Enriquez versus Aula Management Corp. Okay, 5 and 5. Legrand versus USC NY Con LLC. Okay. 5 and 2 and 5. People versus Ricardo Torres. Submit. Century Indemnity versus Brooklyn Union.
Your Honor, there's a cross appeal in this case.
Yes.
Did the court want to do the appeal?
We're doing it all together.
All together, then I would ask for 7 and 4.
Okay.
And on behalf of respondent, 7 and 4.
Okay, 7 and 4 and 7 and 4. I was prepared for bigger numbers, but I'm pleased. I think you're going to end up with bigger numbers anyway. Jones versus Jacobs.
For appellant, I have 6 and 2, Your Honor.
Okay.
Stephen Jacobs, respondent, 5.
6 and 2 and 5. People versus Jamel Maldonado. That's a submit. 4th Avenue Owners versus Douglas Elliman.
4 minutes and 1 minute.
Let's do 4 and 1 and 6, okay? People versus Lee Stanton. Okay.
7, Your Honor.
7 and 2 and 7. MTA versus Trinity.
For appellant, 7 and 2.
Okay.
5 minutes to respond.
7 and 2 and 5. People versus John Hamlet.
Appellant request 7 and 2.
Okay.
Request 7, Your Honor.
7 and 2 and 7. New York Marine versus Rockingham Insurance.
Good afternoon, Justice. And I got it for Rockingham, 5 and 1.
Okay.
For the respondent, Olympia Price, New York Marine, 8.
Okay. 5 and 1 and 6. Nunes versus CH Housing.
For appellant, 7 and 2.
Okay.
Respondent, 5, please.
Okay. This ain't that complicated. 5 and 1 and 5. Okay. People versus William Rivera. That's a submit. Yang versus Governor's Office of Storm Recovery. That appeal was withdrawn. And Allied World versus AIG Specialty. That is a submit. First argued case on the calendar is Enriquez versus Aula Management.
Morning, Your Honor.
Good morning.
This is-
Good afternoon.
As you know, this is a slip and fall case. The issue presented is whether the plaintiff can serve as her own notice witness. And the answer is obviously yes. It happens all the time. Plaintiff serves as her own notice witness. In the routine case, plaintiff says she saw something before and then she later fell, or he later fell, and she serves as her own notice witness. It's a double-edged sword. The plaintiff can serve as the lack of notice witness for the defendant. And this is nothing new. You have Pagan, you have Rivera. These are First Department cases. You've decided this many times in the past. When the plaintiff says, I was walked up, this defect is right by the plaintiff's door. This is how she has to walk past this all the time. She has a railing. She walks down the railing. She's a heavy woman. I don't mean to be disparaging. She always stands on, grabs the railing and walks down. The night before, she said she went home and it was fine. The next day, she comes early in the morning and she falls. She never sees anything. She just feels on her derriere that it's a little wet. That's the same as Pagan. It's the same as Rivera. It's the same as all these cases where the plaintiff is in the area and before they don't see anything and after they fall. This is no different than what we've had before. You don't even have to go that far. You don't have to get to notice. The courts tell us.
But the fact that the plaintiff did not see the water before that, that does not conclusively establish your lack of notice, does it?
Yes, because in order to
What case holds that?
In order to be an actual defect, it has to be visible and apparent. It doesn't have to have a magnifying glass. You don't need to be a specialist. She never saw the water after the accident.
We have had a lot of plaintiffs who fall and didn't see the substance they fell on before falling, and nonetheless, their cases end up at trial. So that alone doesn't win the day, counsel.
She didn't see.
How do you establish your prima facie case in the first instance here?
She didn't. We're saying it's non-actual because she never saw it before or after. Nobody ever saw.
Do I have an affidavit, perhaps I missed it, from whoever cleaned immediately before this accident?
We have an affidavit from the supervisor. We don't have it.
Who has no personal knowledge about anything?
Right, we're not basing it on
So,
that.
except that the case law requires, where you are the movement, that you have established certain things prima facie before we even get to the plaintiff's response.
With all due
And did you satisfy that?
Yes, with all due respect, you have said, and First Department has said, you don't need it. Pagan and Rivera. That's exactly the point. And the Court of Appeals has said, with the one time when you said it's not necessary, the Court of Appeals said you're wrong. That's enough. If the plaintiff said that.
And the facts in those cases are
don't-
on all squares? Okay, I will take a look. I don't think you're right, but I will take a look again.
I appreciate it. Thank you.
Thank you.
These are your notes?
Oh, I'm sorry.
Yeah. Want to make sure you keep those. Okay.
You may proceed.
Good afternoon, Your Honors. May it please the Court. I represent the plaintiff respondent, Ms. Enriquez, and
Counsel, are the facts in the cases cited by your opponent analogous to your case?
the cases cited by my opponent, Pagan and Rivera, are not analogous.
And how do you distinguish them?
Well, in Pagan, there was testimony and affidavit, I believe affidavits and probably testimony as well, from both a supervisor and a cleaner as to when the area was last inspected.
So in those cases, the defendant satisfied its prima facie burden in the first instance?
Yes, there would, at that point, they could argue, legitimately argue that they had no constructive notice because they actually put forward when the area was last inspected. Here, there is no information about when the area was last inspected. The person that testified, Ms. Manganelli, is in her words, she is one of the inspectors or building managers.
She talked about what the general procedure
Exactly,
is,
Your
but
Honor.
not specifically what happened on the day of the accident.
Exactly. She also couldn't remember whether she was even in the building during the month or the months before, or when she was last in the building prior to this.
Counsel, your case isn't just about a wet landing or a wet step. It also involves a railing that
Exactly,
that
Your
is
Honor.
connected by wiring, which I thought was a
Well,
little
yes,
unusual.
there was wire on the railing, and it's a question of when was the area even last inspected by the building owners and managers.
Was there evidence in the record that there was another way out of the building so that this plaintiff, who, as your adversary pointed out, obviously would have had to know that there was a banister being held up by a hanger, basically, that somehow absolves the landlord of the condition of that stairwell.
Well, according to testimony, there are two wings in the building. Each one of the wings has its own stairway down to the main lobby. Each one of those stairways evidently has this wire that is attached to the stairway at various points on the edges. In this case, the railing itself gave way with regard to the plaintiff grabbing for it as she was falling. Had it stayed in place, it is very likely that she would have been able to stand upright or at least minimize the extent of her damages. Because it gave way, she was caused to continue falling and landed awkwardly, breaking her leg. That's the basis of our case. If there's nothing else, thank you very much, Your Honor.
Thank you. All right. Yeah, he didn't ask for rebuttal time. Okay. LeGrand versus USC New York Con LLC. You may proceed.
Good afternoon, Your Honors, and Happy New Year. Monica Romero for Appellants. And I would like to focus on the fact that there are no issues of fact in this case. Plaintiff's argument is that because...
How can you say there's no issues of fact in this case?
I'm getting...
We have a plaintiff who says, I stopped at the stop sign, proceeded because the cars coming in my direction were far enough for me to complete my turn. He says he stopped behind other vehicles at a red light and gets hit from behind by the cement truck.
Right. The description of plaintiff's events, it's implausible. First of all, there is...
And we're going to find that as a matter of law on a summary judgment motion where we have plaintiffs saying the opposite of what your client says?
Yes, the evidence on the record supports my client.
How?
The evidence on the record does not.
How?
So first of all, there's a physical damage to the vehicle, right? And it is plaintiff's contention that he completed his turn and he was on Skillman Avenue, stopped at a red light, and that a 30,000-pound cement truck then hit his vehicle in the back, right? But the damage to the vehicle is limited to the lower left corner.
In the back.
Lower left corner.
In the back.
Yeah, but it's just one corner.
Which means that part of his car was hit in the back. The fact that, because according to the record, he had not completely been able to turn his car completely straight onto Stillwell, so it was slightly on an angle,
No,
which would conform.
His testimony is that he completed his turn.
Okay.
That was his testimony. If the court wants to search the record and
I
find
have.
different grounds, but that was his testimony, and I'm certain. I've read it numerous times.
Okay.
So if his version of the facts were true, right, then you can imagine that the whole entire back bumper would have been damaged if he had in fact been waiting at that red light and been hit by a 30,000-pound cement truck.
But counsel, isn't that if that you posit really a question of fact for the trier of fact, the jurors?
I think that in the normal courses of business, so to speak, but in here, the evidence is conclusive. Like the pictures of the vehicles are there. There's a video that was submitted to the court of the aftermath.
A video created by your client.
Of course.
So that is not exactly, it's not like it's video from the street surveillance showing how the accident happened.
Right.
It doesn't have that kind of weight. This is a piece of trial evidence created by an expert hired by your client.
Absolutely.
That doesn't have the same weight.
Even if you assume that the vehicles had been moved in the video, there's still the debris of the accident, of the aftermath, right? And if the accident had in fact happened on Skillman Avenue while waiting for the green light at Thompson.
Doesn't your driver admit that because of the hood of his cement truck, he doesn't even see the car he hits?
He,
which would place him in violation automatically of the VTL, where you have a duty to see what there is to be seen on the road in front of you. He admits he does not see the car.
plaintiff also admits he does not see the cement truck, and it is.
Which is why it comes down to this being a quintessential question of fact for the jurors.
But it is not, that version of the events is not plausible, right? That there is no evidence on the record that supports that version of the events other than the testimony. And when the testimony is not physically possible, then the court can disregard that.
But
And in
if
this
your
case-
client did not observe what he was duty-bound to observe, which was another car, another vehicle in the roadway, and avoid hitting that roadway, and we have a vehicle which was hit, then therein lies the question of fact for the jurors.
Right, but I submit that it is my client who had the right of way. And if the plaintiff is
So
starting
even though he
to-
has the right of way, he doesn't have to observe other vehicles which may be within the roadway?
No,
That absolves him of his duty to not hit another vehicle in the roadway?
no, that is not what I'm trying to say. I apologize if that's what was transmitted. No, but he had the right of way, right? And if there is a vehicle that is
Well, but that's an issue of fact, because the plaintiff says he was already in the intersection. So that is a quintessential issue of fact. I realize that your argument and your experts say it's absolutely impossible. I get it. But that's an issue of fact for the jury to decide, because we have a plaintiff who says, I was already in the street, in the intersection, and he hits me.
Yes, Your Honor, but if a plaintiff comes here and says, you know, you have all of the evidence in the record that the sky is blue, and you have a plaintiff that shows up and says the sky is green, if there is no evidence on the record to support that assertion,
But there is evidence
be
in the record. The
disregarded.
plaintiff's testimony is evidence.
it's completely impossible.
Okay. All right, we're going in circles. You have any other arguments other
Yes,
than
if
it's
I may.
completely impossible?
Right. They did say in their brief that the video submitted, you know, like they said, oh, well, maybe the car was, didn't complete the turn. However, the testimony of, plaintiff never testified to those facts. He never said, I did not complete my turn. I was in the middle of the road trying to complete it when I was hit. No, he testifies, I completed my turn. I was on Skillman Avenue waiting at that red light. That was his testimony.
Right.
And then I will add that when it comes to their expert report, that they also claim that creates issues of fact, it really does not have any technical value, right? It has no engineering analysis whatsoever that could support the plaintiff's versions of the event.
You said it had no technical value?
There's no engineering analysis, right? And it contains a number of medical opinions and legal conclusions. And not only that, but it contradicts plaintiff.
And your experts didn't, right? Okay.
No, they didn't. If I may, they just.
You have 5 seconds.
Okay, they just said physical damage does not support a front-to-rear engagement in their expert report. So with that.
Thank you.
We'll wait for rebuttal.
Good afternoon, Your Honors. May it please the court, Jack Lockwood for the plaintiff respondent. Just to reiterate, this is defendant's motion for summary judgment. The evidence must be viewed in the light most favorable to the plaintiff. The defendants have not done that here. They're cherry-picking evidence, testimony, mischaracterizing.
Can you just respond to defendant's argument in the briefs that your expert opinion was questionable or could not be relied upon because your expert changed the testimony of the plaintiff? That's what she claimed in the briefs, at least in part.
Yes, that's the defendant's claim. Of course, we don't get to our expert unless the defendants met their burden.
But assuming.
I would point out that the defendant's expert relied on disputed issues of fact in their affidavit.
Which disputed issues of fact?
Disputed issues of fact?
Which ones?
As to whether the plaintiff stopped at the stop sign, as to whether the plaintiff was in
And
the
that's disputed? Is that your contention?
The defendants are disputing that, yes. Plaintiff testified that he stopped at the stop sign, that he made a turn onto Skillman Avenue, or Skillman Avenue, and that he moved a couple of feet after the stop sign. So, and when you look at the aerial photographs of this intersection at 327, 328 in the record, this is a very sharp angle. Sorry, I digressed a little bit from your question, Your Honor. So the question about the plaintiff's expert. The plaintiff's expert acknowledged that that plaintiff testified that he was stopped at the time of the accident. Plaintiff's expert acknowledged all of plaintiff's testimony and specifically rebutted the issues raised by the defendant's expert. One was as to the front to rear manner of the mechanism of the accident. The plaintiff's expert addressed that at 424 to 425, whether the damage to the front bumper of the truck and the...
Counsel, how do you handle the argument that the way in which the plaintiff described this accident is incredible as a matter of law, given that there's no damage to the actual rear of the vehicle?
There is
Rather
damage to the rear
side.
of the vehicle, Your Honor. I think if you look at the page 331, there's a picture of the back of the plaintiff's Honda Civic,
The side.
the rear side panel, and the back tail light. And the debris that defendants are talking about is the tail light. It's the red, you can see it in the pictures, in the photographs. Plaintiff's testimony is entirely consistent with the photographic evidence and the video evidence. And
So the way you're saying it's a sharp angle, you could be on Stillman Avenue coming out of the stop sign, but be angular.
correct, Your Honor. And he testified that he only could move a couple of feet after the stop sign before there was a car in front of him and he was stopped at a red light. He was stopped for a couple of seconds, and then he feels the rear impact.
And it's my question about him being at an angle, not being directly behind the vehicle in front of him on Skillman, was an accurate statement.
Yes, so the defendants are citing to testimony, I think at 171 to 174, where the plaintiff is talking about the position of the vehicles after the accident and trying to use that to create an issue to try to establish that plaintiff's argument is that there was a rear to front collision. He plainly testified, if you review the testimony, that he was struck in the left rear of his vehicle, which is consistent with the damage and consistent with the video, which doesn't show the actual accident. It's a video that was taken after the accident. Plaintiff's expert also addressed that actual issue as to whether, and explained how getting struck at that angle, if his car was positioned at an angle, it could result in it moving it to where it was ended up at the end of the after the accident was over. So plaintiff's expert actually explains all of that in his affidavit. Unless Your Honors have any further questions, I'll rely on my brief. Thank you.
Thank you. You have 2 minutes.
Your Honors, I would start by noting that plaintiff actually testified that he moved anywhere from a couple of feet to 6 feet after his turn. So
After what?
after his turn from 29th on to Skillman. So just a couple of feet was not the estimate that he gave. He actually went from 2 to 7, 6 feet,
2 to 6 feet
2 to 6 feet.
in a car.
Yes, and his car. And regardless of the description of the aftermath, plaintiff consistently states that he's at the red light waiting, and he stopped there for a few seconds when he's hit in the back. Now, if that was the damage done to just the lower left corner, the damage would be so much worse if it had been hit in the back, as he describes. It's a 30,000-pound cement truck. It's not possible that there would not be a scratch.
Also, he got out of his vehicle after this accident. He knew where the car was damaged. There are photographs of the damaged vehicle. We have that,
Of course.
okay? It's still toward the back of the car.
Mm-hmm.
Okay.
Which would be consistent with if he tried to turn, and
Or
my
if his
client was
car
going
was
to-
already at an angle, and because we're able to say it could be consistent with this, or it could be consistent with something else, that means that there's a question of fact for the trier of fact, not for the court to decide as a matter of law.
Right, it is not for the court to decide as a matter of law based on the testimony that it's before it. And the testimony before it does not support that the plaintiff was at an angle. So I completely agree that it shouldn't be for the court to decide that.
It should be for the jury to decide. Thank you so much for your argument. Century Indemnity versus Brooklyn Union.
Your Honor.
You may proceed.
Thank you, Your Honor. May it please the court, Anton Matlitsky for Century. I'd like to start with the trial court's holding that the jury must first conduct a pro rata allocation before determining whether Brooklyn Union's 1993 notice was timely.
So I want to be clear in my head. What I can't figure out after reviewing the briefs and records here is why you even had a jury trial. But this is not a simple case. So, as I understand it, you take issue with certain jury instructions, principally given to the jury in deciding the notice question, principally,
Two
correct?
instructions, yeah.
So it's your view that there should not have been, the factor of pro rata cost allocation should not have been a factor for the jury to weigh in as to the timing of the notice? Is that your position?
Not exactly, Your Honor. So there are two principal rules that we think apply. One is that if the policyholder is going to rely on pro rata allocation in explaining the timing of its notice, it has to show that it actually relied on it. That's the local
Right,
case.
so because the Court of Appeal decided that issue years after they gave notice, how could that have been a factor? That's your position?
Right, and that's what Lilco holds. It was the same thing in Lilco. But that's first. And then second, if they had considered pro rata allocation, then there would be a question of whether that consideration was reasonable at the time during the notice period. So we aren't saying that, and we were precluded from offering any evidence about that at all. And it's not that we're saying that the jury shouldn't have been able to consider allocation as a factor, because that's not what happened. What happened was the jury was directed that it had to allocate pro rata, the expected damages before determining when notice would be due. In other words, the jury had to assume that Brooklyn Union did take pro rata allocation into account, even though the evidence, I don't think they would disagree, is precisely to the contrary. And that's inconsistent with...
You're asking for a new trial, right?
Yes.
And if it went back for a new trial, is it your position that the jury, the next jury, should not have to consider a pro rata allocation at all in making their determination? Or it's just one of the factors, or what is your position on that?
So in principle, they could consider allocation if the policyholder could, in a different case, if the policyholder showed that the policyholder consider allocation.
But I mean, we're talking
In this
about
case,
this
no.
case.
In this case, no, and that's exactly the same thing as in Lilco. Your Honor, you were probably remember we're on the court later in Lilco.
Yes, I
You had
was.
a late notice issue before you, and this is how the court, Your Honor, explained the holding in Lilco. It rejected the claim that the insured could reasonably consider allocation in determining the figure at which the excess insurance coverage would come into play as to each site, which would have required the defendants to show the presence of higher potential cost figures before notice was due. Exactly their argument in this case, right? Lilco rejected that precise argument. It was almost the same case. It was our policies, right? It was an MGP case. It was the same thing. So
So your argument is that it's not always the case that a jury cannot consider pro rata allocation, but in this particular case, the jury shouldn't even be given that as a factor to consider when answering the notice question.
Right, because just to take a step back, the way that notice works, the notice inquiry works in New York is, you're supposed to give notice when an accident happens. But if you don't, it's okay if you give a reason, your actual reason for why you didn't give notice, and then you show that that reason was reasonable.
And,
right?
and does that analysis change at all? Because here, the insured had a self-insured retention, right? The first 100,000
Right.
Belonged to Brooklyn Union, and then the rest was excess. I mean, Century is an excess carrier.
It is, and it doesn't change because that was Lilco. That was exactly, I mean, it was literally the same policies in Lilco. It was our policies.
So I'm confused.
Sure.
We all.
When you had the jury trial and you were discussing the charges,
Yeah.
so basically you're saying what you're saying now, what you should have said before the trial court was, Judge, you cannot, as a matter of law, ask this jury to consider the pro rata cost allocation factor
Yeah.
to determine the reasonableness of the 1993 notices that
Yeah,
they
exactly.
issued,
Yeah.
because that factor didn't exist at that time.
Right, and we said that.
And what happened?
And the judge said, no, that's not right.
Well, a part of it has to do with a previous decision from this court, or a reading of language on a summary judgment appeal motion,
It
right?
does, so let
that
me-
clouded the issues a bit.
Let me see if I can unpack it.
Okay.
If that would be okay. I know I'm running out of time, but,
ahead.
so this is the sentence.
We said this
Okay.
one would take more time. Go
Fair
ahead.
enough. So this is the sentence that they're relying on in that opinion, right at the end. It says,
This is that 2009
2009
decision
one in
from
this
our court.
case. Right. Nor did the court improperly shift the burden of showing pro rata allocation to the insurer, since the issue is notice with respect to undetermined costs, not reimbursement for known costs. Doesn't cite Lilco, says nothing about whether a policyholder can rely on allocation in the notice inquiry if it didn't actually do so when determining the timing of its notice. The sentence has nothing to do with this. Here's what happened. The appeal was almost entirely about whether we were entitled to summary judgment on late notice. And we said we were because it was totally obvious that these sites were completely contaminated. It was totally obvious that New York State was going to come after them. It was totally obvious that it was going to cost tons and tons of money to clean up. And if we're right about all that, they can't escape summary judgment because of pro rata allocation under Lilco, right? The court didn't answer that last part because it said we were wrong about everything else. They said we were wrong about every antecedent argument. We were wrong that there wasn't a dispute about contamination. We were wrong that there wasn't a dispute about the New York's authority to go after them and all that. That's what we had the trial about. We made a separate argument in that case. It was all kind of, if you look at the brief, it was all kind of in the same section of the brief, but the argument was separate. We said also, the way, thank you, the trial court wrote the opinion, it put the burden on us of proving how damages are going to be allocated, right? Because of the way the trial court, I think, described the summary judgment standard. And we said, that's wrong because the insured has the burden of proving how damages will be allocated at the end of the case. And so this court said, no, he didn't. He didn't say that because what he was talking about was notice and not allocation. Or, to actually quote the opinion again, nor did the court improperly shift the burden of showing pro rata allocation to the insurer, since the issue is notice with respect to undetermined costs, not reimbursement for known costs. That portion of the opinion has nothing to do with this. This court didn't decide the actual issue we presented having to do with Lilco. The case that did decide it was Lilco, right? This case didn't sub silentio overrule Lilco, and every other case that has considered this question, as far as I can tell, in New York or in federal court, has ruled for us, cited Lilco, and not a single court has ever cited this court's 2009 opinion in this case having anything to do with this issue.
Counsel, one question. In Brooklyn Union's brief, they indicated that notice was actually early here because they gave notice in 1993, 9 years before they even received any cleanup order.
Right.
How do you respond to that?
So there's a distinction in the policies between notice of occurrence and notice of claim. The claim happened in whenever Your Honor just said 9 years later. Our argument was that they should have known that there was an occurrence that was reasonably likely to involve the policies before that. We thought that that was true as a matter of law. And what this court's 2009 decision was about was, no, there's a dispute of fact. So we tried the dispute of fact, and our argument was, they're saying their notice was, that was a good jury line. That's what they said in their summation. But we said it was all wrong. There were memos that should have tipped them off to contamination. They should have known, based on their internal analyses, that New York State would come after them. They should have known that this was going to cost millions and millions of dollars. And if they didn't know, they had a duty to investigate because they were put on inquiry notice, which is our the second point. It completely.
There were there were a few different policies here. Some went for longer, some went for short, and there were different terms in the policies as to when notice was required. Did that affect the ultimate result?
No, so there are two, let's say there are two separate sets of policies with respect to the late notice provision.
Right.
The two later ones say that notice is due when the policyholder learns of any outcome which in its judgment is likely to result in a claim or claims that involve the policy.
Is that a subjective type of
course.
standard?
Yeah.
Whereas the other four policies had what we will characterize as an objective standard?
No, I disagreed. So I think the other, it's subjective and objective. It's
Doesn't make a difference, really.
Well, I agree it doesn't make a difference, but just to answer your question, nobody in the 24-year litigation history of this case, no one has ever said that there's any difference between those two policies. And there isn't, because the ones that were at issue in Lilco itself are the other ones, not the ones that I just read, but the ones that say appear reasonably likely. And the reason there's no difference is if you ask me, in your judgment, when is your time going to run out, or when does it appear that your time is going to run out? I mean, you're asking me the same question. So that's why nobody has ever actually drawn.
And the answer would be,
The
it
answer
already
is
ran
it already
out.
happened. Exactly. So that's,
Counsel, I'm sorry to interrupt you. One of the other arguments that you put forth is that it was an error not to instruct the jury that there was a duty to investigate the extent of the contamination.
Right.
Are you still putting forth that argument? And if this case is returned back for a new trial, is that one of the bases upon which this court should grant a new trial?
Yes, so I think the way it works is there are two independent arguments for why a new trial on at least notice is required, right? The first one is the one we've been talking about for the last 10 minutes. The second one is what Your Honor just mentioned, the jury instruction. If the court reverses as to the first, we would still hope that the court instructs the trial court that it should instruct on the totally uncontroversial and I think obviously correct proposition of law, even if you don't have to reach the question to reverse, because we don't want to be back here again, on this issue. We really, really don't. But again, I don't think there's any actual controversy that there is a duty to investigate. Their argument is that the jury could have figured it out from the charge that the judge already gave, but that just isn't true. And then I don't know if you want to hear about the last argument.
Why don't we hear from the other side, and you'll have time on rebuttal.
All right, thank you.
Okay? And I'm just going to give you 10 minutes from the jump, since that's about what he got.
Good afternoon, Your Honors. My name is Gretchen Hoff-Varner on behalf of Brooklyn Union. I'm actually just here to introduce my colleague who was admitted to appear and argue this case pro hoc vice with your permission.
Yes, the application is granted.
Thank you, Your Honor. May it please the court.
Yes.
The reason, Your Honor, why there was a trial here is because when this case came before the court in 2009, they heard every argument you just heard now about why notice was late as a matter of law. And what this court held is that there were disputed issues of fact as to whether or not notice was timely. The court sent this back. We went through another 13 years of discovery. And finally, in 2022, after 21 years, we got to present our case to a jury. The jury, after a month-long trial, found as a matter of fact that notice was timely. My colleague laid out the competing arguments that each presented to the jury, but he left out the fact that the jury heard both of those and found that notice was timely. The reason why we've heard
The jury was instructed on both of those points regarding notice, and when I say both of those points, without looking into the pro rata allocation and looking to see whether in fact there was a duty to investigate?
No. With respect to notice, what the jury was instructed, which I think was important, as you've heard, our theory was that notice was early. What the jury heard, it was that in order to find that notice was timely, it had to determine that Brooklyn Union gave notice at or before the time that notice was due. That was what we presented. That's what the evidence supported. What makes this case different?
When was it argued that notice was due? What was the basis of determining when notice was due?
To determine whether or not notice is due. Notice is due when it appears reasonably likely that Century would incur liability. For that to happen, as a matter of fact, it would have to appear reasonably likely that there was contamination, that somebody would assert a claim that would impose liability on Brooklyn Union for that, and that liability would be sufficient to reach the excess policies. It's only at that last step where allocation becomes an issue. What the evidence shows is that—
Why does allocation become an issue on that notice element when that allocation is really about how much liability, how much damage is?
Because in order to exhaust the $100,000 self-insured retention, you would have to allocate the damages across the policies. That's what this court held in 2019, that the policies are subject to pro rata allocation. And maybe if I can give some facts about kind of how this
I'm
works.
sorry, sir, which portion or aspect or provision in our 2019 decision said that?
The first part of the decision in 2019 said that the policies must be interpreted to provide pro rata allocation. The impact of that meant that Century pays only a small percentage of the losses. As of the judgment in 2022, Brooklyn Union's cleanup costs, were $236 million. Century was required to pay $26 million of that. Brooklyn Union must pay the remaining $210. And so, to determine when those policies are ever going to be reached, when the $100,000 is going to be exhausted, you have to take into account the fact that they're only paying 11%, we're paying 89%. They want the jury to be instructed incorrectly and led to believe that Century is going to be on the hook for 100% of the losses, which is just not true. And I want to talk about Lilco. We said this is like Lilco.
I just have one
Yes.
other additional question. If it was obvious that there's a pro rata allocation inquiry, where in the record that was formulated over in discovery over a 20-year period in this litigation, where is there any indication that your client considered the pro rata allocation when determining when to give notice?
What the evidence in the record shows, and you can see this best from Ms. Bell's testimony at pages 810 to 825 of the record, that when notice was given in 1993, there was no expectation that Brooklyn Union would have any liability imposed on it. They did not have any basis at that time to estimate an overall cost. And so when you're in a position in which you think you have zero liability, you're not going to allocate that across any given period of time.
After years of contamination in the Gowanus, that your client was under the impression that there would be no liability even to clean up all of that contamination?
That's correct, and that's what we presented
Decades
to
of
the
contamination.
jury. That's correct, and that's what we presented to the jury, and the reason for that, the facts
It
presented.
costs more than $100,000 just to clean up a gas station. If you want to remediate the land that a gas station was on, it costs you more than that to fix the soil in that kind of property than what we're talking about here.
The evidence in the record, the evidence presented to the jury in which they found that it wasn't reasonably likely that any liability would reach the Century policies is that when notice was given in 1993, the MGP sites at issue here were designated low priority sites. The EPA at the time, their focus was on sites that could—
Low priority sites for cleanup?
Correct.
So, but how
Or-
does
or
being a
investi-
low, how does, that makes no sense to me. How does being a low priority site correlate to the cost for cleanup? The two have nothing to do with one another.
They're related in this way. First, there has to be a cleanup. There has to be liability imposed at all before you even get to the question of how much the cost is going to be. In 2009, the citizen site that was tried in this case was before the court on summary judgment in 2009. What the court said as to the citizen site in 2009 is there's a disputed issue of facts at that time as to whether any action would be taken requiring cleanup at that point in the future. And if I could say what the
Right,
evidence
it's a question of fact, right, to really go to the jury, right? But when the judge made the ruling that the duty to investigate wasn't something that was going to be put before the jury, then certain evidence wasn't allowed to come in, which is why the state of the trial was as it was.
No, I mean, on the duty to investigate, we disagree that there's some freestanding duty to investigate. They have pointed to nothing in the policies that establish that. They point to the...
Is there nothing in the policy? I thought the language of the policy suggests that there's a duty to investigate. And you can continue.
Yeah, I mean, there is on behalf of the insurer after a claim is submitted to them, not on behalf of the policy holder. What the case they rely on, the Orange and Rockland's case, that was a case in which the policyholder said, well, we didn't have actual notice of the extent and the potential for liability. And what the court said there is you couldn't rely on your lack of knowledge.
When you're talking about give notice of an occurrence reasonably likely to involve Century's policies, if something's reasonably likely, that means you have some sort of obligation or duty to investigate if it's reasonably likely.
We don't read it that way. We don't understand Century to have ever made that argument or to read that anyway. What that shows is reasonably likely, shows the likelihood that any liability could be imposed on Century. And I want to talk about, we heard this is the same case about Lilco.
I still can't, I'm sorry, I don't mean to cut you off.
No,
I'm still troubled. If the factor of prorated cost allocation didn't come into being until decades after the notice that was given in 1993, and this involves three MPGs that Brooklyn Union didn't really, they were abandoned. They were all shut, 19, whatever it is, in the turn of the century. How can you say that it was appropriate for the jury to consider that factor in determining what was in the minds of Brooklyn Union when it gave its notice in 1993 to be timely? I don't understand that.
Okay,
Especially when there's nothing in the record to suggest that that was even ever a consideration in determining to give notice.
Yeah, so a number of responses. For one, I'll start with the fact that this argument was made and considered and rejected in 2009. And I think the reason...
Counsel, I really need you to answer my colleagues. This is an important case. And if you avoid addressing a direct question which was just put to you, then you leave it to us, okay? And you don't get the benefit of giving us an answer. So I implore you to answer that question and don't go back to your go-to. In 2009, the court said. The court, whatever the court said in 2009, with all due respect to my colleagues, was in response to a summary judgment motion. This is a trial. So please, address my colleague's question.
So the policy language our position has meant the same thing from the time it was drafted in 1950 to today. There may have been disagreement in the 1990s as to what that meant and how allocation applied. That is very common in a contract dispute, that the parties have a disagreement about what the language means. Once a court settles the interpretation of the policy language, it is then very appropriate and common to ask the jury to find, as a matter of fact, whether or not the policy language was satisfied.
So what about the other part of that? Where is there any evidence that in determining when to make to give notice, that what you believe the policy to always include, which is a pro rata allocation, when was that ever a part of the calculus in making that determination to give notice?
Our position is that we complied with the policy and we did not breach that. And when that is the case, you don't need to present subjective evidence of why you complied.
You need to submit some sort of evidence, and respectfully, you're not answering my question, and it's an important question. What do we have before us to rest a decision upon the fact that when your client gave notice, it included in its calculus as to when to give notice, this pro rata allocation.
My answer, and I'm trying to be responsive, is that we didn't need to on that. And let me tell you what the evidence is that establishes that notice was timely. At the time notice was given, our understanding, and this, as I said, was reflected at pages 810 to 825, the testimony there, is that we did not have any expectation that any claim of any amount was going to be asserted for these sites, because at the time, the EPA had said MGP sites were a low priority. The higher priority were sites.
So you gave notice in 1993?
Correct.
So was our court here, none of us were on this panel in 2009, were they wrong when they say that the trial court correctly found an issue of fact whether the insured's duty to give notice had arisen, that's your duty to give notice, had arisen before the city of New York advised the insured, that's you, in January 1993, that it intended to bring a federal environmental action with respect to one of the insured sites. So in 1993, you had noticed that there was potentially going to be an environmental action brought.
And again, going back to my point, even in 1993, any cost to remediate a polluted site would easily go over $100,000 and extend to the excess positive. Easily.
So, no, we think the court was correct to say that there were disputed issues of fact. That was their argument, that as a matter of law, notice needed to be given in 1991. What the discussion was of the claim, and I think this is important, and it plays into the 2009 ruling, but I want to explain why, is there was a claim asserted, a threat to sue Brooklyn Union received from the city of New York related to the Coney Island site, because the city owned some of that property and they wanted to build a garage there. When Brooklyn Union got that claim, it sent it to Century. It sent both the notice of claim, said, we've been threatened to suit as to Coney Island. In that letter, it says, we have these 13 other MGP sites, but there hasn't been any claim asserted against them or any demand that they be investigated and remediated. So the reason that notice was given as to these MGP sites in 1993 is because they were added into a letter that had to do with the Coney Island site. So what the trial court decided when it denied summary judgment in 2007, it said there's a disputed issue of fact as to whether notice was timely for Coney Island. There we have a claim, but the estimated cost of the cleanup for Coney Island was $8 million. And it said there's disputed issues of fact of how pro rata allocation would apply to that $8 million to see whether it would reach the $100,000. For the Citizen site, there's that issue here, and the other sites before the court in 2009, the disputed issue of fact is whether there would have been any claim at all. And that's the decision the court affirmed, which is why we had this trial, and it's why.
And so the Island site was doing the same thing as these sites, right?
It had similar MGP.
So if it costs $8 million in Coney Island, what is the anticipation of what it will cost to clean up with regard to 3 sites?
The costs depend in large part, obviously, first of whether any claim was asserted, but then also what remedy is being selected. And this is testimony in the evidence. It's the same pages, but what the testimony says is it is hard, if not impossible, to predict the costs of a cleanup in advance if you don't know the type of remedy that's going to be ordered.
I believe my colleague had a question.
So we agree that the trial judge's charge to the jury with respect to notice was carved through this lens that there was a pro rata allocation component to the jury's inquiry on notice. We agree on that? That's fair?
That's correct.
Okay. What is, other than our 2009 decision, what would the factual and or legal basis be to provide a jury instruction on the notice issue that contains a pro rata allocation component?
And we would go to the policy language. It is necessary to understand, based on the policy language, how the money is allocated. Let's start with the notice provision itself. The question is when would it appear reasonably likely that Century would incur liability? So when would Century start having to pay money to Brooklyn Union? Century acknowledges that you can't answer that question sort of in the vacuum without looking to the other provisions and understanding how they work. Century acknowledges that the $100,000 self-insured retention has to be exhausted before they have to pay anything. But it's also clear from the court's prior rulings, and they don't dispute, that they don't have to start paying. That $100,000 isn't exhausted until it is exhausted using pro rata allocation. So the pro rata allocation is the method for calculating when you reach the $100,000.
But it's a method of calculate. I'm sorry.
Yeah,
It's a
what
method of
says that?
calculating damages, right? Like the exact precise amount. But whether in fact there is any reason to believe that how much they'll have to pay is over $100,000, you don't necessarily need to do a pro rata allocation to come up with that, because you have a whole other site in Coney Island where it costs $8 million to remediate.
But the notice question isn't when Brooklyn Union has to pay over $100,000. It's clear from the language, the way it's written. The question is when when Century has to start paying money.
So I'm just curious, when should they have given you note? What does your friend say you should have given them timely notice?
I believe
Under these circumstances?
They've changed, I think, their position. Sometimes, as you heard there, said that notice is generally due when you learn of an accident or contamination, but that's wrong. The policy is clear that the obligation to give notice arises when it appears reasonably likely that they're going to have liability. It's not tied to property damage. It's to potential liability. On summary judgment, as you said, they said notice should have been given in 1991. A jury didn't agree with that. And so, the arguments you hear were presented to the jury. The jury was given a chance to hear.
You want to finish your argument now and eat up your 4 minutes of rebuttal?
I can say
Okay.
thank you.
Thank you, Your Honor. Just a few points. So on the argument that the reason that the jury was not just allowed to consider allocation, but was required to consider allocation, their argument is because the policies were later construed to provide for pro rata allocation. That was the exact same thing in Lilco. That was the whole point of that decision. That's what happened. The court held damages would be allocated pro rata. The insured said, well, here's what they actually said. The trial court's grant of summary judgment ignored the critical importance of allocation in determining whether, when, and to what extent the claim became reasonably likely to implicate the SS policies at issue. That was the policyholder's brief, and this court said no, because you didn't consider allocation. That was the whole holding. And now, my friend didn't get to try to distinguish Lilco. I think what they said in their brief was, in Lilco, all the other factors the court had already said meant that notice was late. The only one that was left was this allocation point. But that's an argument for us. It just isolates the actual legal question in this case.
I guess their first point would be the trial judge, we are bound by the 2009 decision, but we've talked about that enough.
Agreed.
So,
Yeah.
what ultimately then is the proper manner in which the jury should have been charged on the notice issue?
So let me start with the second point first, which is that they should have been given a charge about the duty to investigate. I'm surprised that my friend is disagreeing that there is one. The Court of Appeals held in Security Mutual that an insured must exercise reasonable care and diligence to keep itself informed of accidents out of which claims for damages may arise. I mean, I thought that was a pretty well-established rule in New York. And as to the allocation issue, given the facts of this case, the jury should not have, first of all, in the instruction, shouldn't have mentioned anything about allocation at all, certainly when it comes to notice, and they should have been, totally separately, they should have been precluded from arguing allocation in the first place because they never considered it. I mean, we never even got to that because the court said...
For notices purposes, not for
Notice purposes.
damages.
Yes, of course, for notices purposes. Now, the allocation question never should have been put before the jury. There has never been, as far as I know, ever, anywhere, a case when a jury is even told about pro rata allocation for exactly the reason my colleague pointed out at the beginning. You know, they're going to say we're only paying a small percentage of this. Well, that's because that's what New York law is. But it sounds kind of bad to a jury, and it's pretty prejudicial, which is why we think that it's not just the notice issue that is affected by this error. But in any event, there's never been a case before, ever, as far as I know, where a jury has been instructed that they have to conduct a pro rata allocation. And certainly, allocation has never been put before the jury when there's no evidence that the policyholder actually considered allocation at the time. That's what Lilco holds, and that's what there's just no other case on their side.
So you really take the position it's a judicial decision to do the allocation afterwards, almost kind of like in a tort case where Article 16 and you're doing all the calculations at the end to mold a judgment. You would say the same thing here.
About allocation? Yeah, that's how it always works.
I mean, the jury in this case did all kinds of
Math.
I mean, I was looking at the discussion afterwards. They did all kinds of math and figured out, and you minus this and you subtract this, and that's what the jury did in this case.
Yeah, absolutely. Totally unprecedented. It was very strange. First, they had to decide the period of property damage to decide the allocation period.
Yes, when it started, when it ended, and then
and then they had to multiply and
this,
divide and all this stuff. So
you think none of that should have been part of what the jury considered?
in this case, no. Because
In this case,
no.
So what, assuming we agree with you that there needs to be a new trial, assuming there needs to be a new trial, vis-a-vis the issue of notice, what else would need to be retried?
So our position is, well, 2 points. First of all, there were evidentiary rulings that are dependent on what we think is a misunderstanding of the law, and that doesn't need to be retried, but we would say that the court should instruct the trial court to reconsider those rulings in light of the right legal principles. The other thing that would need to be retried is there's this question of when the period of property damages starts and ends. The reason the jury was required to find that is because that then tells the court, after we're all done, the period over which you allocate damages, right? But normally, the jury isn't told why they're being asked to find that, because that would be juries just are not told about allocation. In this case, the reason the jury knew about allocation was because of the trial court's holding as to notice. The jury was going to be instructed about allocation with respect to notice. So now allocation was in the case, and they made an argument, including in summation, that you should consider the fact that damages are going to be allocated pro rata when you're thinking about when property damage should start and end, which is obviously highly prejudicial to us. And there was a very wonky result that I think is probably explained in part, at least, by that prejudice, which is that as to one of the sites, the jury found an end date of property damage that was 5 years earlier than the one that they argued for.
The other thing that's troubling me, I'm not sure it's your friend's issue or your issue, because it's all starting to get a little muddy here. The notion of per occurrence limits over a multi-year policy.
Yes.
Was that something the jury had to calculate here?
So,
and if that's so, it goes against the whole notion of letting the jury know what policies. I mean, we obviously know this is a declaratory judgment action with insurance, but I mean, this whole concept of knowing how much money is in the pot, is that,
so
I'm confused by all that.
Let me, if I could just, there's a history about that issue. That's their cross appeal, so I'll let them talk about it, obviously, but the history is, there was a summary judgment ruling for us, I don't know when it was, I think it was like 2017 or something, that said that as to the policies that extended beyond 1 year, they were unambiguously, the per occurrence limits applied to the total term of those policies rather than renewing annually. That went up to this court, and the court held that no, the policies are ambiguous, which means it went down to be tried. And there was, meaning the policy ambiguity was left to be tried. Sorry.
Go ahead.
No,
the
reason I'm jumping in here, because my understanding, based on my experience, is whenever there's an ambiguity in a contract, it's something that the court usually takes care of.
Well, unless the parties are able to offer extrinsic evidence. So that's what was supposed to happen on remand. They didn't offer extrinsic evidence. We did. we offered an expert on custom and usage that the trial court incorrectly bounced, which we can discuss. But let's assume the trial court was correct, right? To get rid of the expert for the moment. Now we have a case with no extrinsic evidence and an ambiguous policy. So then the question is, does contra proferentum apply? Because if the answer is yes, then the ambiguity has to be construed against us. If the answer is no, then the judge just decides it as a matter of law, right? And so the court, if you want to talk about this contra proferentum issue now, I mean, I think that's the principal dispute between the parties on their cross appeal. Let me just say this. There is a lot of precedent in this court about party sophisticated insurance like this one, where contra proferentum doesn't apply. But I don't think you have to get to that in this case, because they agree that if the parties negotiated the relevant provisions, contra proferentum doesn't apply. They say we didn't negotiate them because it's a foreign policy. But the relevant provisions are the term of the policy and the per occurrence limits. Of course those were negotiated. You could see the negotiations happening. Starting, for example, at page 1830 of volume 4, where there are annual renewals by their broker. And everybody agrees that those annual renewals are for an annual policy. And then
I
all of a
need you
sudden
to
they say
wrap it
25.
up, because while we find this quite invigorating.
I know, you have other.
You have one more? Go
I'm
ahead.
going to give you 20 seconds. If we're giving you a new trial, I want you just bullet points. What are the issues that are going to be tried?
Late notice and the period of property damage.
And what?
The period
Period
when
of
property
property
damage
damage.
ends.
And then damages if necessary.
I think there was a stipulation on that.
Okay.
There wasn't a damages component.
All right, wonderful. Okay, counsel.
Thank you, Your Honor. I mean, I think it's critically important for me if I can get an opportunity to distinguish Lilco. And I think where I want to start is a basic distinction between the first question in a breach of contract case or contract dispute is, did the party breach the agreement? Our theory throughout this case is that we complied with the terms of the contract. What I'm going to talk about in a minute, of what the issue was in Lilco, is the notice there was late. And so the question was, did the policyholder have a good reason for giving late notice? It's a distinction between I complied with the policy versus I breached the contract, but I have a good reason for doing so.
Well, a difference without any distinction. It's all about notice.
But it is an absolutely critical distinction under contract law, whether you complied with a contract or whether you had a good excuse for breaching the contract. In Lilco, if I could say, the issue in Lilco was it was undisputed that Lilco gave notice after the duty to give notice had arose. The court held as a matter of law that notice, the duty had arisen 6 months before notice was given. On the issue of allocation in Lilco, there the evidence at the time notice was given is that the policy's attachment point were $25,000 and the expenses were estimated at $26 million. You could have spread that loss over 1,000 years and you still would have reached the policies. The court held in Lilco that notice was late as a matter of law. And what's your excuse? They said, well, allocation. So we're not going to consider an excuse unless you can actually show you considered that. The same rule doesn't apply for breach. If I comply with a contract—
You're saying breach, but it's really about, did you give notice in a timely fashion, right?
Did we fulfill the requirements of the contract? We said—
Fulfill the notice requirement of
Correct.
the contract, right?
Did we give notice before it appeared reasonably likely that Century would have any liability under the policies? The jury was instructed that to find for us on that issue, it had to determine that we gave notice.
We're talking about how you're distinguishing this case, your case, from Lilco.
Correct.
And let's stay focused on that, because I don't hear you distinguishing it. One was about whether in fact the notice that was given, which everyone agreed was late, whether there was an excuse for giving it late. What we're talking about here is whether in fact notice was given at the appropriate time. We're still talking about the same thing. We're still in a notice bucket, right?
Yes, but we're talking about the difference between breach or complying with the notice policy, the provision of the policy, and having a good excuse for not. If I can draw the distinction between the facts, Lilco
Whether you comply versus whether you have an excuse for not complying, you're saying those two things are different things.
Absolutely. It's a fundamental distinction of contract law of whether you comply with the policy or you had a reason not to. I mean, I think that's, yes.
Either way, you didn't comply, right?
No, absolutely we comply. That's what the jury found. We complied with the policy. It's what the jury found. And if I could just say 1 minute on our cross appeal, the issue of law that we have raised is whether there is a sophisticated insurer exception for contra preferendum. This court, the doctrine itself, the name is construe against the drafter, nothing to do with the sophistication of the party. The two key cases we would point to is the Court of Appeals decision.
Well, you don't do that unless the parties are sophisticated. You don't apply the doctrine, right, unless we're dealing with two parties that are sophisticated.
No, the contra preferendum unquestionably applies when somebody's not sophisticated, and we think the law is clear that even if the policyholder is sophisticated, it still applies. The two decisions I was going to point the court to is the Court of Appeals decision.
And you're saying Brooklyn Union Gas is unsophisticated party here?
We're not saying that.
That's the argument?
No, the argument.
He's saying that they're sophisticated, but it still applies.
Right, we were saying that contra preferendum applies to all policyholders. And I'd point the court.
Whether they're sophisticated or not.
Absolutely, right? Yes. And, I'd point the court to the Second Circuit's decision applying New York law in Morgan.
Held that?
No, but the first
Because
department.
that's the controlling law for us.
Sure, then I'll start with the Court of Appeals, which the Court of Appeals said that the state of New York is entitled to contra preferendum. Where certainly Brooklyn Union isn't more sophisticated in matters of insurance than the state who regulates.
It wasn't one of the factors in the court's ruling that you had your own insurance department, that you actually wrote it. You had staff. You were almost a mini me of Century.
And you did have a self-insured retention, so you were dealing with the insurance issue because you made a choice to, have that first level, so to speak.
Yeah, but if I could answer that on that point.
I'm going to give you 30 seconds because I don't think this is your strongest point. But go ahead. I'm going to let you say what you got to say.
Yeah, I mean, the self-insured retention is no different than a deductible, which I pay for if I have a car accident or I get health insurance, and I don't think anyone would view me then as self-insuring up to the deductible.
You
I don't think
have an
we can
insurance
compare you
office.
as a person to Brooklyn Union Gas. Okay? All right. Thank you, gentlemen and lady. All right. Jones versus Jacobs. You may proceed.
Thank you, Your Honor. Good afternoon. May it please the court, my name's Elliot Martin. I represent the plaintiff appellant. What we start off here, there is a release, which of course is a jural act. It is presumptively binding. And in addition to the fact that there's a release, there's language in the release which excludes unknown claims, which Court of Appeals has said includes fraud. So we have a situation here starting off where there is a longstanding pernicious pattern of fraud, and the court below felt that the language of the Centro Empresarial case and its progeny barred the complaint. And
But your position is there's no ambiguity in the release. We know it looks pretty solid facially.
Yes.
The issue here is whether your client was defrauded in signing that release.
That's correct, Your Honor.
Based upon a material misrepresentation with respect to the alleged filing of the gambling complaint to get the money out from DraftKings, correct?
Yeah, yes. So, as part of a longer pattern, that is just part
That's
of
the heart of your case here.
Well, yes, but I'm just saying that it's not only the DraftKings. The fraud starts at the beginning. However, yes, that is the question, and the Centro case says that that a release should not be the starting point of litigation, that it should be respected unless it would result in a grave injustice. This is what the Central Court said. Here, I think manifestly there's a grave injustice. We have a situation where a layperson went into business with an attorney, and it is important that the defendant is an attorney. Not only generally speaking that he should be held to a higher level than somebody who's not an officer of the court, but part of the plaintiff's viewpoint of this venture was shaped, a great part of it was shaped by the fact that the defendant is an attorney. He presumptively believed this. This is in the complaint. He believed that an attorney would not commit a dishonest act, would not commit an illegal act, and there's a certain level of trust that came from the fact that Mr. Jacobs was an officer of the court. So, but this is where it starts. The venture was funded with $82,000 plus a little bit more in loans. The venture was for Mr. Jacobs to take this money into his betting account, make bets, and split the profits. And the $82,000 came, the profits were duly accrued, and then in the very beginning of 2023, when there was approximately $450,000 in the kitty, the plaintiff asked for this to be distributed. Now, it's important that Mr. Jacobs did not say, I'm not giving you the money. You're not entitled to the money. We have a dispute about the money. The complaint says that $200,000 was going to come to the plaintiff. The defendant didn't say, I'm going to give you $199,000, and there was a dispute. He said, oh, it's not a problem. The money is going to be given to you, but the problem is that DraftKings has not given it to me. Now, that was a lie. Okay, so we start off now with a falsehood. These are co-fiduciaries, and the standard, as important as the fact that Mr. Jacobs had the status as an attorney, he was a co-fiduciary. He was a co-venturer, and he basically then piled on a series of falsehoods, fictitious documents, and he got to the point where the parties were waiting for the state of New York to take DraftKings in hand and force them to give the money.
You said that your client was fraudulently induced into signing a release and a covenant not to sue, right?
That is correct.
And that was because the defendant said that he had filed an application that he had not in fact filed?
No,
Is that part of it?
Actually, it's more than that, Justice Kaplan. What Mr. Jacobs did was pretend to create an administrative complaint based upon a false scenario. He actually did file.
But then he withdrew it or something?
He filed it, sent a copy of the email to the plaintiff, and then 3 minutes later told the Gaming Commission that, no, this is a mistake. Training module, sorry, darn sorry, and here we are. So it's more than that.
Counsel, your adversary indicates in his brief that your client was already suspicious that he was not being accurate. So how can he have been induced to rely on something that he already believed to be false?
Well, there really is no evidence in the record that that's the case. There was some issues with statements in the brief, and the record expanded. But we can certainly deal with that. The question really is not so much whether the client may have had general suspicions or any suspicions. He had no suspicion that this man was lying completely. That the entire scenario presented to him was false. And
you'll have time on rebuttal.
Okay.
Okay?
May it please the court, I'm defendant respondent Stephen Jacobs. I want to pick up on Your Honor's question right there. There is a great deal of evidence in the record that the relationship was extraordinarily hostile for a whole host of reasons at the time that his client signed the release.
You say this like it benefits you.
Well,
and what I want to know is, since when is it appropriate for an attorney in a fiduciary relationship to lie to his partner?
Your Honor.
Answer my question.
Of course, Your Honor. It's not appropriate. This was an extraordinary.
And there's no question that that is precisely what you did.
Yes, Your Honor, but there was extreme extenuating circumstances here. There were in the record in the lower court. They're not particularly in the record here, which was that his client was working with someone very dangerous that accosted me outside my building, for which I had to go to the police and the FBI, and for which my understanding is there's currently an FBI investigation underway.
Is that in the record?
It was in the record in the lower
Is that in the record here?
No, Your Honor.
So you know, as a practicing attorney, that you should not be asserting arguments that are towards the record. Okay?
Understood, Your Honor. It is. You're correct that it is inappropriate to lie. Although I would dispute that I had any fiduciary duties to Mr. Jones as an initial matter. There's no.
From the inception of this arrangement, you had no fiduciary relationship with this person?
Well, I don't think there's anything.
You take $82,000 of his money to file bets, and there's no fiduciary relationship?
Maybe at a certain point there was.
At what point?
If the record were exactly as he said.
No, I'm asking you. You're part of the record. So at what point did you have a fiduciary responsibility?
Yes, Your Honor. If Mr. Jones had given me money to do something in particular with it, then yes, I agree there would be fiduciary obligations. Although the relationship he alleges is akin to a stockbroker relationship, and I believe there's law in this department.
You're not a stockbroker.
Well,
you're not a licensed stockbroker, so that doesn't apply. Please.
Okay. But I would like to just add that the Centro and the law in this department since Centro are very clear that you can still release, even if there are fiduciary obligations, they can be released so long as the relationship is not one of unquestioning trust, because without that, the settlement of disputes would be impossible.
But you do not dispute that you told Mr. Jones, please sign the release, and as a condition for signing the release, no, you can trust me that I will be filing a complaint with the Gaming Commission so that we can get that $200,000 I believe I owe you. Yes or no?
No, Your Honor. That is
No,
not.
I thought the threat was that either you sign this release or I will withdraw the complaint that I filed with the commission and you'll never see that money.
Well, that's what he claims the threat was. The actual text messages of that day are extremely different than what he presented. But I agree, Your Honor, that is what the threat that he puts in his complaint. But I think the law is clear.
But that was an empty threat because you had already withdrawn the pretend complaint.
Yes, Your Honor. But again, I think the law in this department is very clear that fraudulent inducement cannot invalidate a release for two reasons under circumstances like this. Number one, there needs to be some sort of fraudulent representation that is separate from the subject matter of the release. Here, the subject matter of the release is the entire venture, our entire dealings with each other.
No, the subject matter is the complaint that you allegedly filed.
No, Your Honor, that's not the subject matter of the release. The subject matter of the release, if you look at it's all claims
Well, yeah, the
whatsoever.
subject matter of the release is getting his money, right? In general, right?
Correct.
But
It's
the
everything.
fraud alleged here is that fake complaint.
But that fake complaint is part of the subject matter of the release, which is all of our dealings related to the DraftKings venture. So that there's a whole host of First Department cases on this subject.
So are you arguing that as a matter of public policy that this court should condone a release, right, for which was obtained because the issue in the release is not the complaint, but the release was obtained because you lied to the person in order to get them to sign that release?
Well, again, that's what he contends. So yes, Your Honor. Under
Okay.
these, but I would
He contends it, or is that not what happened? right? Because a part of getting the release, right, the way in which you obtained the release was by telling him that you had filed the complaint. But the record reflects that you had already retracted that complaint.
Again, he contends that that's why he signed the release. I contend if this matter goes to discovery, it would be totally different. But to answer Your Honor's specific question, Centro Empresarial, the Court of Appeals held just that. In that case, a party presented a totally fraudulent balance sheet that the other side relied on to sign a release. And it went to the Court of Appeals, and the Court of Appeals said, well, the real issue is you didn't realize the value of the claims you were giving up. And the reason, the policy behind this rule of the separate fraud rule is that otherwise any sort of fraud claim could never be settled with finality. So that's reason number one. And if you may indulge me, I'd like to give you the second reason in this department why releases are upheld under these circumstances. And again, there's scores of case law referenced in my brief that says when there's language in the release that says, I didn't rely on any representations outside of the release, the party claiming fraudulent inducement is forbade from claiming justifiable reliance, which is an element of fraudulent inducement.
All right, thank you.
Thank you.
You have 2 minutes on rebuttal.
Yes, Your Honor, thank you. All right, I mean, let's look at this release. This release is, it's not a bona fide commercial instrument. There's no negotiations. This panel has, all of you, had many cases involving Centro. These cases uniformly are commercial disputes, genuine commercial disputes. You decided one way, you decided the other way. This is not. There was nothing going on here except that the defendant was threatening to withdraw something he never filed in the first place in order to panic the plaintiff into signing a document that the defendant knew that he was going to waive before the court and attempt to basically defraud the client of his rights.
And he basically kept the money.
And he kept the money, and it's the worst thing. And it's from the beginning. It's alleged in the complaint that the defendant never intended from the outset to share the money, and that is supported by the defendant's litigation strategy, where he interposed the illegality of his own betting, his own taking the money, his own betting. He's there as an attorney. He's doing this with a co-fiduciary, and he had his backup plan set. This is a scam from the beginning, and again, you can cut this any way. I believe that this court really just needs to reverse the lower court. Thank you so much.
Fourth Avenue Owners versus Douglas Elliman Property Management. You may proceed, sir.
This case is really pretty simple. It's enforceability of a limited liability provision, which simply states the building managing agent will not be liable for any loss or damage he does not directly cause. The claim boils down to the question, is the managing agent's failure to catch the utility pilfering commercial tenants primary cause of loss? I submit to you, and please excuse the hyperbole, that this is akin to, was the failure of the policeman to catch the bank robber a primary cause of the bank's loss? It's my thinking that the court below decided
That is a terrible analogy, with all due respect.
I withdraw that.
Terrible analogy.
I'm going to withdraw that analogy, and I'm just going to say to you that.
Okay.
Instead, I would say to you that this particular this particular thing with a tenant as pilfering commercial.
This was so easy to manage. And your client had managed this issue with other commercial tenants before. So it kind of strains credulity that they didn't understand that they had to, I mean, it's simple. Knock on the tenant's door. Can I see a copy of the Con Ed of your own utility bill lease? Right? That's all it took.
I'm going to answer that for you, because that's a good question. That is the question. And I would submit to you this. If you look at the management agreement, I believe that's on record page. Let me give you the record page. That is record page 73. First paragraph. It tells you This has 179 units, plus various commercial tenants. I respectfully submit to you that
Well, this only applied to commercial tenants, right?
this particular thing...
Because every apartment has to set up their own utility,
Yeah.
right? So we're talking about
know
just not 179 tenants. We're talking only about the commercial tenants,
That's right.
right?
We are.
And two in particular on the same floor, I believe, right?
Well, they're on the first floor, that's right.
Okay.
And they were required by their lease
Right.
to get direct utility accounts with the...
And weren't you obligated under the management agreement to check all the bills on a monthly basis and make sure everything was okay? And it was years that these tenants, that these commercial tenants were there using the building's electrical service.
Well, in all fairness to my client, in fact, the management agreement at paragraph K, and the site for that is...
Okay, well, go ahead. We'll find it.
Paragraph K simply says that the managing agent must use best efforts to collect rent and other charges. I respectfully submit to you that the limited liability provision, which we are skipping over, specifically says...
But you're ignoring G.
G
says check all bills received.
Check all bills received. They wouldn't have received this bill because if you look at the managing agent gave...
Well, apparently they did receive the bill from Con Ed directly and for services not for them.
They received the bills they paid in the ordinary course, but be aware of the fact, in fairness, this is an agent, not a guarantor, and the court says, and I quote to you what the court said specifically that the agent was charged with making sure the various commercial tenants arrange for electricity directly with the utility. With respect, there is nothing in that managing agreement that makes the managing agent a surety. The real point I wanted to make to you is that...
Not a surety, but a manager to manage what was
management
required.
is not a guarantor. That's
Whoa, you're talking over me. I was still talking.
I'm sorry.
The management agreement gave your client responsibilities to manage, not to be a surety.
But it also had a limited liability provision that we're just not addressing. And it says that there would be no liability for this agent unless they're the direct primary cause of loss. That is what they agreed to. And I want to point something else out.
Well, the primary cause of loss was your noncompliance with paragraph 4 of the management agreement.
The primary...
But paragraph, just bear with me. Paragraph 4, as I understand it, you had an obligation to ensure the commercial tenants were complying with their leases by setting up their own electrical accounts.
I'm sorry.
So that's you directly caused the commercial tenants not to pay their electricity.
Well, where was that provision is not in the management agreement. What you just quoted does not come out of the management agreement. If you are looking at the complaint and those paragraphs of the complaint, that is not from the management agreement. The management agreement does not have any of those.
You'll have time on rebuttal.
Please, the court. Jeremy Krantz, Smith and Krantz for the respondent and plaintiff. Let me just clarify a number of things that counsel has again mischaracterized. He did the same thing before Justice Adams. The transcript of the proceeding actually says, from his mouth, it is further conceded that Chrysler Management Contract, which is the underlying contract that his client took over, does require the defendant managing agent to bill tenants for utility charges. Period. Right out of his mouth in the transcript before Justice Adams. That is in your transcript 5. Okay? Appellant chose on this record to move for summary judgment with an individual who had no personal knowledge on anything, had no personal knowledge on the underlying issues, the electric charges, the billing records, anything. The individual that had some knowledge of that was Brenda Ballison. Brenda Ballison, as you correctly pointed out, Your Honor, knew how to handle this with the Valley National Bank. You don't transfer the account, you don't pay your bills, we send you a shutoff notice for the very same Douglas Elliman for my client. We're going to shut you off. And that's in the record. And I can give you the record references. They chose to resolve it that way. Brenda Ballison apparently left a Urd 4-day took over, then someone else apparently either dropped the ball, fell asleep at the wheel, or whatever, and didn't look at the leases that came in, the commercial leases for this premises. So what happened?
Brett, how do you answer his point, though, that with respect to the limitation of liability clause, that his client's negligence in the management of the company was not the primary cause of the economic loss here?
Okay, so here's how that addressed. His client had total access and control over a special account generated by Douglas Elliman for the purpose of paying itself and for paying other vendors and other entities. They did that consistently with this Avid Realty, or whatever the name is, company that paid the bills automatically. They set this thing up without reviewing the leases, as they're required to do as the managing agent, as they did with Brenda Ballison, when they did it with Valley National, and they didn't do it when they were advised back in 2013 by my client to say, hey, check on the Con Ed accounts. They fell asleep at the wheel, and they don't want to pay. Okay, so getting back to contrast of his client moving for summary judgment, my client cross-moved for summary judgment based upon the fact that they thought they were going to get summary judgment on a failure to mitigate and approximate cause, which I don't even know what they were trying to say with that cause of a defense, to be honest with you. They sort of dropped it in oral argument before Judge Adams. We came forth with an affidavit with personal knowledge from Eric Einstein, proof deposition of John Janginello, who was the actual person they brought forth at the deposition, who I deposed, who said, I wasn't there, I don't know what happened. It's like no disrespect, like an old Jackie Mason routine. I don't know where it was, I wasn't there, it happened many years ago, and I wasn't in control. We introduced the leases with Digart and the dentist. We introduced the Brenda Ballison correspondence, which was the prior tenant, as I stated earlier.
You just had two commercial tenants.
couldn't hear
You just had two commercial tenants in this property?
They only
At any
were,
time?
we're only dealing with the commercial tenants.
Right, there were two commercial tenants.
Right, and in fact,
It wasn't like you had hundreds of commercial tenants.
Well, I think there were more, but John Janginello actually stated in his deposition, hey, we really do mostly residential. We really don't know what we're doing here. That's what he said in his deposition.
Mr. Krantz, on
Yes,
a
Your Honor.
separate point, knowing what the record says in terms of the commercial lessee being responsible for electricity, why didn't you ever go after the commercial tenant to mitigate damage?
That's a very good question. So there's several points on that issue, which I'll get to. One is, one of the things that was supposed to be provided in the cause of action was accounting, either a judicial accounting or some type of accounting that would allow us to know exactly what the amounts were. In fact, at some point, the Avid Utility, by the way, was the name of the company. At some point, the internal manager of Douglas Elliman gave us a spreadsheet, it's in the record, that said it's approximately $109,000 for Digart and $37,000 for the dentist around 2020. But that's not accounting. That's the spreadsheet. They don't tell us what the underlying documents were for Con Ed. They don't produce the documents. They don't produce us a record. I asked for that stuff at the deposition, not provided. We asked for judicial accounting as a cause of action. Justice Adams correctly pointed out we were entitled to that. Getting to the issue of the mitigation. How do you compute the damages? How do you go after the tenants? One of the tenants had already left. Digart had already gone. So, and then it's hard to mitigate. It's very hard to mitigate when a tenant's already left, especially when the tenant is...
How about the dentist who was still there?
Right, and the dentist is still there. That's another issue which I will get to. The issue here is how far back can we go to seek these claims that have never been accounted for, that have never been provided for us on the complaint for a period of time approximately 2012 to 2021. How far back can we do this, and how do we prove our case for a mitigation when we haven't even been provided the accounting? So Justice Adams correctly pointed out on their papers, they failed to prove as a defense mitigation. They failed to prove the right to seek a mitigation of damages as a defense because they put in an affidavit from somebody who had no knowledge about the underlying numbers, who had no knowledge about the underlying transactions between the parties regarding Con Ed bills, and they said, this is what we're going to go with. They went with that. They also went with affirmations from counsel, and on reply papers to our cross motion, they didn't put an affidavit in.
All right. Thank you.
First of all, that's that's just not so. The affidavit of the managing agent who was there, the one that, the people they're talking about left. They left. They're not there anymore. This business is a turnover business. There is an affidavit in the record from the managing agent. And at record page 93, he tells you the reason they screwed this up is they were not directed to open an account. They were not looking for a willful breach by these tenants. That's why they didn't look for it. Okay, they fell asleep at the wheel, but that's why these type of contracts have these limited liabilities provisions. They're agents. They manage hundreds of units. These people come and go. They don't stay. So the fact that this one wasn't there, this is standard. And I also submit to you, all of these managing...
So building owners have to eat the losses caused by property managers' mistakes?
Not necessarily, because...
Well, that's what you're saying here.
That's what he's
For
saying.
9 years' worth of electric
mistake with
council, you keep on doing that. But you know what? It doesn't matter. You're out of time. Thank you. People versus Lee Stanton. Thank you. You may proceed.
All right. Good afternoon, Your Honors. May it please the court. I'm Stephen Nemec. I'm here on behalf of Lee Stanton. Mr. Stanton, who's now 73 years old, he was 67 at the time of the attempted robbery in this case. He served roughly 7 years of a 12-to-life sentence. And so I'd like to start with the first point we raised in our brief, which addresses the sufficiency of the evidence of physical injury, because physical injury is the difference here between attempted second and attempted third-degree robbery, which created a massive gap in sentencing exposure here. I believe his 12 to life was mandatory under the persistent violent felony offender statute, and under the attempted third, he would have faced, I believe, a maximum of 5 years, even as a second felony offender. So the underlying incident here is a failed robbery in the West Village that was almost immediately interrupted by police.
Not immediately enough.
The whole incident lasted about a minute. Based on the police officer's testimony and response, he shows up, they were stuck in that vestibule for about 30 minutes. The way the story goes, Mr. Rincon, who's in his late 30s, is leaving a bar in the West Village as the bar is closing. He's admittedly testified to being quite drunk, had trouble finding the subway. He testifies that Mr. Stanton pushes him in the vestibule of a townhouse on 10th Street, if I recall.
You're leaving out that he sought help from your client, and in exchange for that request for help, he ends up getting robbed.
Yes. Yeah, that was the transaction in play there. Mr. Stanton pushes him in the vestibule and starts to try to take money from his pockets. In doing so, the testimony from Mr. Rincon is that he was punched once in the face and several times in the leg while Mr. Stanton's trying to pull things out. I think there was several receipts pulled from a back pocket type of thing while they were fighting over an envelope of cash in the front right pocket.
Where he was being punched in the leg.
Yes, exactly. That is Mr. Rincon's testimony. The officer who shows up sees them in the vestibule, sees them struggling over that. Doesn't see any punches.
We understand the facts. Why is the complainant's testimony of pain that lasted over several days not sufficient under our case law?
He says he felt pain, and I believe
a lot of pain.
He says those words, quote, a lot of pain in his legs specifically for about 3 days.
Right.
That's the testimony. But the legislature did not intend going all the way back to matter.
That's enough. Under our case law, that is enough. It just has to not be a mere shove or what's the exact language? Yeah, slap, a shove, petty slaps or punches. These were sharp blows. He was punched in the middle of his face.
The testimony
right?
is yes, exactly.
And
He testified at the time.
such that he was black and blue afterwards.
So he testified. By the way, he testified that he did not feel any pain from those punches while this is happening.
Called adrenaline.
And well, exactly, and that's fine. But that it is about the experience of pain here. Why he can't? I don't think the case law doesn't stand for the idea that he can say it's a lot and that gets you all the way there. It's not a wholly subjective standard.
And Chittick isn't to the contrary of that, which is why Chittick, I mean, that's going back all the way to Philip A. This would fall with petty slaps, kicks and shoves out of hostility, meanness, and other similar motives. That's what we have here as he's trying to take his money. Chittick says the most important thing to look at is what did those blows cause? What did those injuries result in? And what we have here are basically no medical treatments required.
Not required.
It's not strictly required, but it's effective.
No, it's not required, not strictly, it's not required.
It's not necessary, but when it is not necessary, it is also a sign that the injuries suffered were not as severe as other injuries that do require it. It's a factor. When you have it, it supports a finding of substantial pain and physical injury. When you don't, it supports a finding that those injuries weren't as severe. We have 3 pictures of his legs taken 3 days after in a dimly lit bathroom that, even between 3 and 4, there's some slight discoloration. Even the trial court concluded that those pictures didn't show bruises. Instead, there was, quote, still some redness where the bruises had been. So our point on that is that just saying it hurt a lot doesn't get you there. And objectively speaking, looking at the nature of the injuries caused from that attempted robbery, which nobody's disputing, I mean, this is obviously a bad situation for the complainant, didn't get you all the way to physical injury. All robberies are going to involve forcible taking. There has to be something between attempted third and that application of force has to result in a physical injury to get you to second. So with the light on, I'm going to switch to our third point because the legal landscape has changed quite a bit since we initially filed our opening brief. And so he was sentenced to 12 to life under the persistent violent felony offender statute. The statutes that authorize that sentence are unconstitutional because they require judicial fact-finding on issues that increase the penalty beyond the statutory maximum. The idea of that claim dates all the way back to Apprendi in 2000. There's a ton of litigation in the Court of Appeals. Much of it focuses on the discretionary persistent felony offender statute. Since we filed that brief, the Supreme Court decides United States, Erlanger v. I can never pronounce it right, sorry. Erlanger v. United States, which says it changes nothing and everything. It says we meant what we said in Apprendi, but we really meant what we said in Apprendi, which is that if you have to do anything more than identify the defendant's previous convictions and the legal elements required to sustain them, the enhanced sentence is invalid. And so with the persistent violence statute, there's a few things you have to do, and most saliently is the tolling period you have to get. I mean, the first violent felony we're tolling back to here in Mr. Stan's case is all the way back to 1981. And so that's not. I should mention here that there's a case pending in the Court of Appeals that's probably being argued as we speak that addresses the same issue. People v. Mitchell Hernandez, which has about 58 parties, and the AG's intervened. I will say here that objection, counsel objected on this issue at sentencing, so it is preserved. It's on page 6. His objection alluded to the litany of that. I mean, the Apprendi challenges have really dominated a lot of the Court of Appeals jurisprudence, but I would like to note that the prosecution hasn't contested the merits of that claim. So it's a new issue. It's developing, but that is and the remedy there would be to vacate the sentence and remand for resentencing.
Okay, you have a minute on rebuttal.
That's fine.
Counsel?
Good afternoon, Your Honors. Hunter Barron for the people. I would like to start with point 1, physical injury. As Your Honors alluded to, the victim's on stand saying that he felt a lot of pain. That's way above the threshold of what Chittick requires, and that was entirely reasonable in this case for him to feel. I mean, just some of the facts. He testified that the defendant pushed him into an entryway, down a set of stairs 4 feet away. His head bounced against the door. That was his word. The defendant punched him in the face between the eye and the nose, put him in a chokehold, and then he punched his leg more than 5 times. And that punching of the leg was in direct response to the victim trying to resist the defendant rummaging through his pockets. So the defendant's clear motive in inflicting those blows was to inflict pain. And so I think, there's very compelling evidence introduced by the people that physical injury element was met at trial. Unless your honors have any further questions on that point, I can move on to point 3 on the Sixth Amendment. The defense raises this claim, but there are a variety of barriers to him raising that claim before this court. The first and foremost, that he failed to preserve it below. His objection before the trial court was too vague to preserve. He merely said that he was challenging the persistent violent felony statute under the state and federal constitutions. He didn't mention Apprendi or the Sixth Amendment, and he didn't even point to exactly what component of the statute he was challenging, whether it was tolling or something else.
If we find that it is preserved, what's your argument?
Yes, Your Honor. So next is the waiver point. The defense counsel noted that they were not, I do want to get the language right here, they said they saw no legitimate challenge to tolling, and then doubled down by saying that an unrelated constitutional claim to his 1981 conviction was the only possible challenge they could foresee to the predicate statement. I think that kind of very broad, very powerful waiver encompasses the constitutional claim that they're now making on appeal. So unless your honors have any...
What about the cases that your colleague indicated were up in the Court of Appeals? I mean, the Hernandez case, is that bear on this at all? Is that the same issue? Are you familiar with it?
Well, I think this court can decide this case without looking to what the Court of Appeals decides, because this claim is ultimately unpreserved. But I am aware that we are arguing in that case that that on preservation grounds, as well as the fact that Erlinger is a very narrow decision that does not apply to New York's predicate tolling provisions. So unless your honors have any further questions.
Thank you.
Okay, thank you, your honors.
Counsel, I was mistaken, you had 2 minutes.
All right, perfect. Good, I'll use them too. On the waiver issue, on the waiver issue, the idea that counsel did not object to the tolling date specifically does not encompass a waiver of his challenge to the constitutionality of the statute. And in fact, like the procedural requirement in CPL 400.15, I think it's subsection 3, that he object or otherwise those facts are deemed admitted, would also be a violation if the right to a jury has attached to the finding of those facts. That's not how, for example, like a guilty plea works. So that doesn't encompass a waiver of something he objected. The waiver would have to be affirmative and knowing, and at no point did they discuss waiving that right specifically. I've also, on the preservation issue specifically, and I bring it up now because it's also part of what's the case that's on appeal, and just to use my last couple minutes, because it is a big thing in the Court of Appeals right now. The case that's pending in the Court of Appeals addresses that 10+ rule of like, the idea that the time between the commission of the very first felony and the sentence date could be used to toll the 10 years. That's what initially it was up for. Erlinger comes out, supplemental briefing is ordered. It's an unpreserved Erlinger claim in that case. They have, among other exceptions, said it should be reviewed under the illegal sentence exception, which we've spelled out in our brief as something that's readily apparent from the record. All of the problems are in the statute. You should just rule on it that way, which we have raised here. And so anyway, I just wanted to draw your attention to that pending case, and we'll see how it went there when we get back. So thank you.
MTA versus Trinity New York City Hotel.
May it please the court, John Nikolic, representing Metropolitan Transportation Authority and New York City Transit Authority, which we refer to as the MTA together. And MTA requests that this court reverse Supreme Court order which dismissed each of the 4 claims in MTA's complaint. In a prior litigation, this court previously addressed certain matters at issue in this case and vacated 2 preliminary injunctions in a TRO that were issued by the same Supreme Court justice who issued the order now on appeal. On this appeal, MTA submits that Supreme Court made errors of law and improperly decided factual matters in a manner inappropriate on a motion under CPLR 3211. In summary, MTA is seeking damages from Trinity Hotel because during construction of Trinity's hotel project, Trinity refused to vacate sidewalk space that MTA needed to allow a neighboring developer, whom we call 42 Trinity, to construct an elevator to the Rector Street subway station for purposes of making the station ADA accessible. MTA has asserted 3 claims based on...
Didn't you have an agreement with Trinity New York City Hotel that they were building on that property? And I mean, how could they vacate the property if they were still building on it? I mean, you made another agreement with 40. They said they were going to build the elevator, and then you said, okay, forget it, you're not going to build it, we'll work something out with you, we're letting somebody else is going to build it. But I mean, how could they just leave the property if they were building on that
They
property?
don't have to leave the property. The agreement, the amendment that we entered into specifically said that they consent to having the transit authority or its contractors,
Or a third
including
party.
40, to appear on the sidewalk. So what we needed them to do, very simply, was to vacate, take down their construction fence, make alternate arrangements, which were possible, to allow 42 Trinity to build that before 42 Trinity finished its project and disbanded its construction team.
Given the level of sophistication of the MTA and their attorneys, wouldn't it have been a simple matter to put it in the agreement that in addition to allowing access, that any obstructions would be moved from the sidewalk and street?
On March, yeah.
At this point, you're I guess...
On March 3rd, MTA wrote to Trinity that Trinity can proceed with construction on its own schedule and is not required to halt or speed up construction based on the installation schedule of the new elevator.
That's correct. They
So
didn't...
why could they not rely on that?
Yes, but what they could do without halting or speeding up is vacating the sidewalk.
But where in that agreement did it require them to do that?
It says specifically that they consent to having the transit authority or 42 Trinity to use the sidewalk. So if
But it didn't say use the sidewalk instead of me. Why couldn't that space be shared?
It couldn't be shared because they had the fence up that prevented 42 Trinity from installing the elevator.
Well, is there any evidence in the record that you attempted to get them to share the space with 42 Trinity as opposed to get out so that 42 Trinity could do their work? Which was the tenor of the communication, get out.
That's right. We issued a stop work order, but MTA was exercising its rights under the Public Authorities Law to access the sidewalk, as this court found in the prior litigation, that MTA had the right to do that. And in addition, this court also said that we had a claim because Trinity Hotel did not get our consent to continued consent to their construction, so which was within a certain number of feet of the subway station. We did give them a consent, but it expired, and the consent very clearly said, in I think 4 different instances, that it expired. And this court held that we had a claim based on the fact that they continued after that expired. So based on the language of the agreement, with their clear consent to allowing us...
Was that language raised here?
Excuse me?
Was that language raised here in this?
Yes, it's very clearly in our briefs, and it's in the record.
Okay.
And it says, it's a consent, and I'm quoting, to work being performed by the transit authority and/or third parties, including but not limited to 42 Trinity and their employees, contractors, consultants within the sidewalk and vault space adjacent to the property for the construction of the new elevator and the new stair. This is on the record page 277.
Okay.
So it's a very clear consent, and the whole purpose.
Yeah, but the consent doesn't mean you had a property right to the sidewalk, which is an element of private nuisance. You didn't have a property right. You had the right to be there to do what you needed to do, but you didn't have a property right for purposes of that cause of action. So under 3211, how are you able to sustain that claim?
No, because we exercise rights under the Public Authorities Law, which this court held gave the Transit Authority the right to occupy the sidewalk.
The right to occupy the sidewalk, but not exclude others.
And you're conflating those two.
No, well, I think if you read this court's prior decision, it very clearly indicates that we get to occupy the sidewalk.
Counsel, you keep on repeating the language. Yes, this case said that. But as my colleague just pointed out, it did not say to the exclusion of others.
Okay, but if they're consenting in their agreement for us to be on that sidewalk, then they have to make accommodations.
How big is this sidewalk?
Excuse me?
How big is the sidewalk that both parties could not have sidewalk sheds on the sidewalk?
I'm not sure that, that's not really in the record, so I'm not prepared to address that. But.
All right, well, you'll have time on rebuttal.
Good afternoon, William Freed for Trinity. I want to address some, as Your Honor rightfully pointed out, there's a letter from March of 2017, and by the way, it's followed up by the amendment to the easement agreement. This is really not a dispute about whether whether my client agreed that the MTA could occupy at some point and do work. It's all about timing. But I first want to address one of the arguments that the MTA keeps making, and they've done it today and they did it in their briefs. They are conflating this case with the prior case before this court. That case, which I handled and argued and lost the appeal here, was about whether the MTA had the right to exercise its rights under Public Authority Law 1266. This court made its decision. This case is not about that. This is a case where the MTA, incredibly, is seeking millions of dollars in damages from my client. A lot has happened since that decision by this court. Let's talk about some of the things that have happened.
So long as it's in the record.
All in the record.
Okay.
No, Judge, I listened very carefully, and I also understand the rules.
Okay.
I wouldn't address anything that's not, but very simply, I don't want to spend a lot of time because our briefs lay a lot of this out. Number one, that my client finished its project. Number two, we voluntarily resolved that case. It's over. Number three, the MTA settled with another party, which they told us and they've told this court, they did to avoid the potential costs of litigation and aggravation. That's wonderful that they decided to do that. Did they tell us that they were settling with 42 Trinity? No. Have they disclosed the settlement to this court or to my client? No. In fact, they actually had the chutzpah to argue to this court and said it to us that you'll find that out in discovery. That's what discovery is for.
Isn't one of the things that they're seeking in this case is legal fees for the other case?
I'm not quite sure, Judge.
They want to recover on the undertaking that...
They're arguing their last claim in this case is for the improper injunction.
That was issued in
they
that
get the
case.
fees. The problem with that, and that's actually a very simple, I didn't want to spend too much time on that, but the answer to that is there was no final determination on the merits of that case.
You say this case was resolved, this Article 7.
The underlying, the prior case that was before this court has been resolved, settled, resolved. They did it without prejudice, but there was never a determination on the merits of that injunction before the trial court, and the law in this department is eminently clear that without a final determination, they can't make a claim on that. They should have proceeded in that case and made that claim, and they would have done so. But I want to be clear. They're asking, it's a dangerous precedent they're asking to set here. They want this court to say it's okay, and Judge Adams smacked it down properly. They went and settled with another party that we had nothing to do with. They took a payment from that party, and they're now saying to us, well, someday we might actually build that elevator, and it may cost more money, we don't know, and you should pay the difference, whatever that difference might be. And the claim that they're making, and Judge, you already talked about the nuisance claim. Both of their nuisance claims are quite clear that they can't satisfy them. One, they don't have a property right. The second one, on the public nuisance, the sidewalk, to Your Honor's point, the sidewalk never closed and the subway station never closed, so that's out the door. But let me just finish on their main claim, which is this breach of the duty of utmost good faith and fair dealing, which they say we've deprived them. That's the real claim here with the real money, is that we've deprived them of the benefit of the easement agreement. Your Honor, you pointed out there's a letter a few months before that agreement in which it says that my client, may proceed with construction on its own schedule. How they can argue that we should have gotten off the sidewalk to let them on, and by the way, there is evidence in the record that we tried to work with them and they would not. There is evidence in the record. We would have worked with them. They did not want to do it our way. So that's what I said. This is really not about whether they had the right to occupy the sidewalk at some time. Of course they did. We understand you're building a hotel in front of a subway station. You must work with the MTA. We get that. This is about the timing. What they wanted us to do was shut down our project at an enormous cost to a developer who borrowed money to do the project, as you can imagine, and give them a year for their other developer friend to do work for them. It's just not fathomable. Thank you.
You have 2 minutes.
Briefly, and one of the things that council just said is that MTA wanted to shut down their project. Absolutely false. There were communications with the building department, which are in the record, where they could have made changes and allowed us on the sidewalk and continue their construction. We were not trying to shut them down at all.
But how do we know that those changes would not have delayed the progress that they needed to make to ensure that their project was completed in a timely fashion?
Well, they've never given us the information to show what those changes would have done. So again, they're raising all sorts of factual issues that shouldn't be decided on a motion to dismiss under CPLR 3211. Council also pointed out that we dismissed the prior case. We did. Both sides dismissed without prejudice, which allows us to relitigate those issues here in this case. So the fact that we dismissed, and there were communications, some of which are in the record, many are not, so I'm not going to get into them, but there were ongoing communications to try and work things out. So they failed, and it got to a point where 42 Trinity had finished its project, disbanded its construction, and we cited cases. They had a good claim because the delay of 3 years gave them a claim for frustration of purpose to get out of the contract completely. So we accepted a termination payment and are now looking for the additional damages that the MTA will suffer by having to build this. Council makes all these statements, well, you never know, they may never build this elevator, things like that. Those are all factual issues for trial and not for a motion on under CPLR 3211. Same thing with, he said, well, we'll give it to you in discovery. This was not a summary judgment motion where we had to come forward with the evidence. It was a motion based on the pleadings. Thank you, Your Honor.
Thank you so much. People versus John Hamlet. You may proceed.
May it please the court, Samuel Steinbach Pratt from the Office of the Appellate Defender on behalf of Mr. Hamlet.
Your voice is coming through loud and clear.
Excellent. I'm happy to hear that, Your Honor. Mr. Hamlet's waiver of the right to counsel was not valid because the record does not show that he had an accurate and meaningful understanding of the sentence he faced if convicted. Contrary to respondents' contention, People v. Blue did not retreat from that long-standing requirement. The narrow issue
When you say he was not aware of the sentence he was facing, we're not talking about the sentence he ended up with, which by operation of law doesn't exceed 50 years anyway, right?
Correct.
Because as I understand it, the recommendation at various points was 50 years. At the best he got was 25 years consecutive to a 7-year sentence, which was still 32, and then had a sentence offered of 37. So in any circumstance, he knew he was looking at least 3 decades of time, right?
Yes,
Okay.
but so the sentence he actually receives and the sentence he was facing is, of course, 154 years. And I think
No, again, that is the number that is quoted on his sentencing, but you and I know that based on New York State law, by operation of law, it does not exceed 50 years.
So I think the Court of Appeals has clarified that that's a statute that's directed solely to docs, but doesn't affect the actual length of the sentence. And in fact, in Blue, what I was going to say is during the colloquies that the court gave that the Court of Appeals found to be sufficient, the way the court talked about the sentence in Blue was not based on applying the cap, and the Court of Appeals never suggested that that was the proper reference. So I don't think that's the right way to think about it. I think the total sentence imposed is the right way to think about it. The other issue in this case, unlike in Blue, is that in Blue, the trial court had 3 separate colloquies with the defendant where he warned the defendant in varying terms that he faced a very long sentence. Mr. Blue each time affirmed that he understood. That's one of the crucial pieces that's missing
What
here.
about the discussion during the suppression hearing where the prosecutor said to the defendant, based on your past record and the crimes, you know, you could spend the rest of your natural life in prison. Is that fair to say? Yes, I guess so. You could die in jail. Isn't that true? It's possible. And he had been permitted at least twice before to represent himself. What about those factors? Doesn't that help to make up for some of the things you're saying may not have been as explicit in this case as you might have liked?
It's certainly relevant, Your Honor. I don't think it's enough to save the waiver for a couple reasons. First of all, I do think it matters, although it's not dispositive, that this is coming from the prosecutor and not the court. The court is the neutral arbiter in a way that the prosecutor is just not. Again, I don't think that's dispositive, but I think it's worth noting. More importantly, the way this question is worded, he's asked, could you spend the rest of your life in prison? He says, I guess. You could die in jail. It's possible. I think it's fair to say, first, those are fairly equivocal answers, but more importantly, I mean, it's possible for anyone to die in prison no matter the length of their sentence, unfortunately. I mean, it is possible for people to suffer untimely deaths. I don't think that
But
really...
the natural import of that was not that he would suffer an untimely death, but that the sentence, based upon his criminal record, would be lengthy.
I don't think it's clear, Your Honor,
It is counsel, please. I mean, really?
I mean, there's no doubt
Really?
he knew he faced a lengthy
That he thought, oh yeah, maybe somebody's gonna throw me over a ledge somewhere in the prison. Clearly, the entire colloquy and the answers back and forth between the prosecutor and the defendant clearly were about the time he would do in jail.
Respectfully, Your Honor, there's no doubt, as we discussed, that Mr. Hamlet knew he was facing a sentence of at least multiple decades because of the plea offers. I think what's lacking here is any affirmative indication that he understood he was facing a century and a half. And I think the whole point of this colloquy, as the Court of Appeals has said in multiple cases, is to remove the requirement of speculation and to provide a sound basis for appellate review. We can fill in...
The standard is for us to look at the totality of the circumstances on the record as they appear, right?
Yes, Your Honor. I don't think that...
And it's not speculation to say he represented himself before. This judge was very familiar with him from the suppression hearing, from having the case before this judge, for a number of years. That's not speculation.
No, Your Honor, I did want to address that. I think those would go to a lot of other factors about whether the waiver was adequate, but they don't really speak to this because his representation of himself in prior cases doesn't really inform his understanding of the sentence in this case, where the exposure was much higher than in those prior cases, nor does the judge's observation of his...
What we're actually looking at is, did he understand the perils or disadvantages of representing himself? And we're required to look at it from the lens of the totality of the circumstances, right?
Yes, Your Honor.
Which would include such factors as whether he understood the sentence, whether he had represented himself before. It includes all of those things, right?
It's all relevant, Your Honor. I just don't think it's enough in a case where the court never once raises sentence with the defendant. I'd like to very briefly...
Sir, would you agree that he was aware that if convicted, he would likely serve a lengthy prison sentence?
Yes, I think that's clear from the plea offers.
And isn't that, though, one of the principles that emerged from Blue?
I think it's different because in Blue, the court does actually give a number in Blue, 25, 30, 40 years, which is actually longer than Mr. Blue ends up serving. So again, I think that what comes out here might be sufficient in a lot of cases. I think given the disparity between the terms that were actually mentioned on the record and what he was actually facing and received, I don't think it's enough in this case. I'd like to just very briefly touch...
Are you saying that at no point it could be, at no point no one said to him, these cases could be sentenced consecutively?
On the
yeah.
On the record, I don't believe that's ever said. I'm sure my friend will correct me if I'm wrong. I don't believe there's anywhere in the record that anyone ever says the terms could be run consecutively. They just throw out numbers without explaining.
Okay. All right.
I'd just like to very briefly, before my time is up, touch on the media exposure point. In a case with pretty extensive media coverage and two extremely prejudicial articles, Mr. Hamlet made what I think is a pretty modest request that the court ask the jurors if they'd seen the articles in question. The court refused. That was an abuse of its
He made the
discretion.
request after how many days after the article came out? So it seemed to me, I think that your argument would be a lot stronger if he had made that request immediately and it had been denied. But after the court engages on the subject, to reintroduce it again to the jury only highlights it, only creates the potential for more prejudice. So I don't understand this particular argument because of the delay in the request.
I see my light is on. If I could
You
just...
can respond, of course.
So two things about that. To begin with, I think it's clear that the issue is still preserved. The Court of Appeals made that clear in Cantave. And with respect to the prejudice, I mean, the jurors already knew that these articles had been published. The court told them that.
And the court gave a curative instruction when it was brought to the court's attention, and nobody objected to that instruction, right?
That is correct, but the court still had the opportunity to make the inquiry Mr. Hamlet requested when he requested it, and I think it would have been prudent to do so given, you know, the jurors already knew the articles were out there. The court's instruction told them to ignore it, yes, but I mean, these are articles in the Daily News and the Post. It's very likely that one or more of the jurors might have seen them, and the court never told the jurors, you know, if you see this, let us know so we can address it. So we don't have any way of knowing if the jurors did or didn't.
If you see it, don't read it, is what basically.
Is what he said.
Well, yes, but I mean, even that, it's not like the headlines mention Mr. Hamlet's name, so the jurors wouldn't even know to stop reading until they'd already gotten some of the information. There's some tremendously prejudicial content.
I think the article names would have already cued any juror with the lights on would have known that that was their case.
If the court had made a minimal inquiry, we would know for sure, Your Honor, and I don't think we should let this conviction stand on conjecture.
Okay.
Thank you.
Good afternoon, Your Honors. May it please the court, Franklin Gunther on behalf of the people. Starting with the waiver of counsel point, I think there's two aspects to this claim that this court needs to keep in mind. First is the adequacy of the colloquy itself, and then is from there you look to the voluntariness of the waiver based on the totality of the record. And with the first aspect, the Court of Appeals has made extremely clear now in blue that there is no specific question that must be asked of the defendant at the time that they make the request. There were cases from this court that sort of suggested that the court's failure to ask a specific question might render the entire waiver invalid, and that is no longer the law. So with respect to the first aspect, I think that is clear cut.
But brevity is not always a virtue, right? And the stakes here are pretty high.
Absolutely.
Given the defendant's sentencing exposure. So was there enough meat on this bone to say that there was a knowing and involuntary decision to go pro se?
I think there is. And just to put a button on that point, I mean, I think that's a threshold issue. There are many cases where this court or the Court of Appeals has thrown out a waiver where there's no colloquy whatsoever, or the judge makes some kind of assumption about the defendant's voluntariness. With respect to the totality and whether this waiver was valid, I think the totality, as your Honor pointed out, well establishes that this defendant was well aware of the consequences and the risks of proceeding pro se.
With the record, isn't it fair to say that the judge made some assumptions here? Because
Well,
there are certain parts of the colloquy that is just non-existent.
Well, the judge does make some remarks at the beginning, basically saying, I've observed you over the last few years. I've observed you at the suppression hearing. I believe that you understand what's going on. But what the Court of Appeals has also said in blue is that can be a case-by-case determination based on the circumstances of the defendant, the charges, other factors. And I would just point the court to the Von Malke case where there was a defendant who there was actually record evidence that she didn't even know what right she was waiving. And then the Court of Appeals decision in Lawrence S. where you had an underage defendant who was clearly inexperienced with the criminal justice system. And in those situations, the court has said it was incumbent upon the court to ask additional questions to assure itself that this defendant knows what he or she is doing before they waive that right. In this case, I don't think you have that problem because, as your honors have noted, this defendant was 31 years old, multiple convictions, including 2 recent ones while this trial was pending, both of which he had represented himself, and he assured the court during the colloquy that he had cross-examined all of the witnesses and had made closing arguments in both of those cases. And so all of those things together show that this was a voluntary...
Is there anything in the record that establishes that this defendant understood that his exposure was triple the highest offer he was given? I mean, that's important because if you're going to allow a defendant to represent themselves, then and they have an exposure of 150 years, okay, and every offer has been 50 and under, you don't think perhaps that's one fact that the judge should have told?
It's certainly a consideration, but I think this is another really important part about Blue is that the idea that the judge needs to disclose the maximum exposure in years is simply not a requirement now. What the court says, as Justice Hagan noted, is that the defendant must be aware that I would also just say it as a side note, my reading of Blue, I don't see a part where the court even explicitly says that the defendant must be aware of his exposure in sort of a global sense. But even taking this as a requirement, the court said that it was clear from the record that the defendant likely would serve a lengthy prison sentence if convicted. And so I think in that context, where you are less concerned about the number of years and more about the severity of the sentence, and to your Honor's point, this idea of the 154-year sentence actually capping itself at 50, that's relevant because the practical effect of your sentence is the risk. It's the practical risk that you are undertaking by waiving counsel. It's not the symbolic additional 104 years that is capped on top of it. It is what is your actual sentencing exposure in terms of a general sense of severity. And so I think to the extent that that is a requirement after Blue, I think you clearly have that on this record. And just briefly, if I can address the media point, I mean, this court and the Court of Appeals has stressed that the only situation where a court is required to inquire of the jurors whether they have read negative press coverages is if there is some evidence that that has actually happened. In other situations, the Supreme Court has and the Court of Appeals has given trial judges a lot of discretion in this area, particularly as in this case where the judge repeatedly reminds the jurors, you are not allowed to read any coverage of any kind about this case, which happened at many stages of voir dire, many stages of the trial, and at the time that the articles were published. To Justice Kapnick's point, immediately told the jurors, there's articles in the tabloids, you are to ignore them, don't look for them, and if you find them, ignore them because they're not evidence. And so I think on that record, the judge clearly did not abuse his discretion in sort of allowing this late request to suddenly ask all the jurors whether they had read them.
And this about looking at any newspaper articles is something that the judge routinely gave every day.
Yes, both at the voir dire stage and throughout trial. And on the day that the articles were, like the second that the judge found out that these articles were published, the first thing the court addressed when the jurors were brought in was, there are two tabloid articles that have been published about this case. Don't look for them, and if you find them, ignore them because they're not evidence, and you should just focus on the evidence. So I think based on all those factors, it's not an abuse of discretion. Unless there are further questions, we ask that you affirm.
Thank you.
Thank you.
Counsel, you have 2 minutes on rebuttal.
Just briefly, I'm not 100% positive about this, but I did just want to alert the court. I don't recall there being continuing warnings throughout trial. Counsel is certainly correct that there were warnings to ignore news reports during voir dire, and then I believe once when this issue was raised. I don't think it was something the judge did every day when the jury was dismissed. With respect to the pro se point, I would just like to flag for the court that one thing to consider in assessing the risks of self-representation with respect to the actual maximum term he was facing, even given the statutory cap, is it affects the risk-benefit analysis in terms of how many counts he'd need to be convicted of before that maximum starts to materialize, right? If he thinks the maximum is somewhere around 50 years if he's convicted of everything, that's very different from him hitting 50 years as soon as he's convicted of 2 counts, for example, as was actually the case. So I think that's another reason why the actual 154 years was relevant in this case, even given the statutory cap in terms of how it affects his analysis of the risks of self-representation and his understanding of what could happen. And I'll note that every time they talk about the amount of time he's going to spend in prison, it's always talked about as if he's convicted of everything. And then finally, I didn't have time to address it initially, but just very briefly, if in the event the court doesn't reverse his conviction, I would urge it to reduce his sentence in the interest of justice. I think 154 years is a pretty extraordinary term, and even given the very, very serious facts here, I don't think
What do you suggest?
I'm sorry?
And what would you suggest?
What we're requesting, Your Honor, is that you simply run all the sentences concurrently, which would obviously result in a sentence of 25 years, but obviously you have any number of options in between that. If you're not willing to go that low, you could also do 30 years, 40 years, really any reduction would obviously be welcome.
What would be the mitigation for concurrent sentences?
It's really just based on the sheer length of the sentence. I mean, this court has reduced sentences much shorter than this, even in cases involving homicides, mandatory persistent offenders.
We're talking about 2 separate criminal transactions, 2 separate complaining witnesses.
Yes.
So what would actually be the mitigation to run those sentences concurrent?
I mean, you don't need to find specific mitigation to run them concurrent. The court has plenary authority to do it, but you could also reduce the sentences and then still run them consecutively, but still for a lower aggregate term than the maximum.
Thank you.
Thank you, Your Honors.
All right, thank you. New York Marine versus Rockingham Insurance. The OCD comes out. You may proceed.
Good evening. May it please the court. Justin Santagata from Cooper Levinson of Rockingham Insurance. I want to start with what is one of the undisputed facts in the record, which was really the quintessential basis of the judge's summary judgment decision below, which is that the copying of the additional insured on a disclaimer to the insured was not sufficient to disclaim coverage to the additional insured. And I think that Valiant, which was actually cited by the respondent, is pretty close. in our favor on that point. The only difference between Valiant and our case is some of the language of the disclaimer, but in our disclaimer, it simply refers to anyone involved in the matter. In Valiant, admittedly, it says any party. That's really the only difference between the two disclaimers.
Yeah, it said it was a disclaimer also to the additional insured.
Yes, conceded, Your Honor.
Which is, you know, what was left out of this letter to the additional insured's attorneys, unfortunately for.
Conceded, Your Honor, and that's why we said in our brief that this is a little bit of a different flavor than a case that has come before. And our position is simply under a strict reading of 3420, when you copy the additional insured, that should be sufficient for any.
We have never held that copying the additional insured is enough. We have never so held.
I understand that, Your Honor.
Right.
But this case in this.
And we have specifically said that a specific disclaimer must be given to each relevant party.
Yes, Your Honor, I understand that. Our position is simply under the statute, when you copy the additional insured, it should be effective as to any basis in the disclaimer, and that's consistent with other cases on waiver of other bases. So when the additional insured receives the disclaimer.
Except it's not consistent with the progeny of case law in this department.
I don't think this particular circumstance has occurred, Your Honor. I agree that it's been close.
Sure it has. It has plenty of times, and we have repeatedly held you must notify all of the people involved. So if an insurance company wants to disclaim as to anyone, they must notify that person, entity, company, whatever it is.
I think the cases, Your Honor, our read of the cases, and obviously Your Honor disagrees, I don't think this particular case has happened. I think there's been two distinctions in the cases. One is whether the person who received it was an agent, and the other was whether the language was sufficient. And this case, there's no dispute about agency. There's a dispute about language. So with all due respect, I think this particular circumstance where the agent was undisputed, a lot of these cases come up in disputes about agency. Moving on to my second point.
Well, what is the strongest authority either from the Court of Appeals or our court to support your position?
I believe it's Valiant. I believe it is Valiant. I mean, if Valiant is not sufficient, then.
No, because Valiant included the other additional insureds. And if your policy said that, we wouldn't be here.
There's no dispute about that, Your Honor.
Right?
There's no dispute if the letter said a little bit more, it would be exactly identical to Valiant. I think saying in the letter, anyone involved in this matter, and again, how this comes before Rockingham is
the whole purpose of giving a disclaimer is to give notice to the party who's not going to be covered under the insurance, right? How does an anyone covered do that?
That's not what it says, Your Honor. It says,
and anyone else involved. Involved in what?
That's what I'm about to answer, Your Honor. This comes before Rockingham, and this is undisputed. It comes before Rockingham. The whole series of receipt of letters is all convoluted. I'll get to that. But may I continue, Your Honor?
Yes.
Thank you.
You don't have a red light yet.
I know, but I know it's going to go over. I know it's going to go over.
Go ahead. You still have a minute.
So this comes before Rockingham when they are served with the third-party complaint by the respondent. So when Rockingham responds, they're responding in the context of this matter. That's the exact quote. This matter, and that's the complaint that includes everyone. So Your Honor's question, in all honesty, the question Your Honor asked was, anyone involved in this matter? That is what it says.
Well, in this matter, does it restrict it to the third-party action? Is it the third-party action and the primary action in this matter? What does that mean?
It means what was sent to Rockingham, and which triggered the response.
It means it wasn't enough. Under our case law, it's not enough. And if you're relying on Valiant, that doesn't get you there because you don't add the additional insureds in the language, which is what made that case different. But you'll have time on rebuttal because now your time is up.
May it please the court, Olivia Gross for the respondent plaintiffs in this matter. The letter that was sent to B&H is very different than the case that was decided in Valiant, and Your Honor, Judge Mansonet was on that panel. I actually pulled the letter that was sent by Utica in that letter, and in that letter, not my letter, in that letter, it said, there is no coverage or defense for this loss for your company or any other party. And the other party was copied on that letter. So that is why this court held that that was sufficient for the piggybacking onto a prior disclaimer letter.
But in light of the language that your friend referenced from his client's letter to your client, isn't the inescapable inference that the disclaimer was applicable to Rockingham?
I'll get to 3420 and how you're not permitted to have inferences under 3420. It needs to be specific. It needs to be direct. And I'm going to talk about that a little bit more in a moment. But in that letter that went to B&H, it says this claim was initially submitted to Rockingham as a notice of default with regard to the complaint and third-party complaint. That's all it mentions. It doesn't mention Astra. It doesn't mention any additional insureds. It doesn't say anything about any other parties. It's saying we are responding to the third-party complaint that was sent to us. That's what it's saying. And I'd like to talk a little bit about 3420 and policies of insurance. Every policy of insurance, every general liability policy of insurance has a separation of insureds provision. We know that under the law, each named insured, each additional insured is treated separately and has its own obligation to give notice to the insurance company. The opposite needs to be true. It needs to be that if you tender to an insurance carrier, that carrier should respond to your tender. You should not have to guess. There should be no inferences. It needs to be very specific. And there's a lot of reasons for that. One of the large reasons is that coverage for the additional insured is different than coverage for the named insured in some respects. It's based on an additional insured endorsement and the language in that additional insured endorsement. When they finally got around to issuing the disclaimer here, they quoted the language of the additional insured endorsement. It was not quoted in the letter to B&H. And there are other circumstances where named insureds and additional insureds need to be apprised differently. Sometimes you'll have an employee exclusion that applies to a named insured, but not an additional insured, or vice versa. Sometimes you'll have a cross-suit exclusion where a named insured cannot sue another named insured. That doesn't apply to an additional insured. So I think that the intellect of Insurance Law 3420 that requires specificity, taking out guesswork, and that notices of disclaimers or exclusions need to be given to each party that tenders. And to the extent that that didn't happen in Valiant, maybe that should have been considered. I don't know if it was argued, but I think the premise of 3420 and the fact that each insured is a separate insured and there's a separation of insured's clause in connection with Insurance Law 3420 needs to require that each insured and each additional insured's own tender be responded to.
Thank you.
Thank you.
Okay, you have 1 minute on rebuttal.
Thank you very much. The only point I would make in reference to what was actually said by my friend is that we don't disagree that anything not said in the disclaimer would be waived. I mean, we don't disagree with that position. 80% overlap, maybe 90% between insured and additional insured. Usually it overlaps. And what we're asking for is simply that when you get a copy of a disclaimer and you know that it addresses the same policy, it's this matter. I mean, it was based upon a complaint that was served on our clients that included the additional insured. So this matter, in all common parlance, is referring to the thing we received. This matter, we use the word matter all the time as lawyers. It was received by my friend who was a lawyer. We would ask for a common sense interpretation of that receipt. Thank you very much for your time.
Thank you. And last but not least, Nunes versus CH Housing Development. You may proceed.
Good afternoon, Your Honors, and may it please the court. My name is Jung Hoon Yang on behalf of the defendant's appellants. I'd like to start off with the preservation issue regarding the applicability of Section 118A of the Workers' Comp Law. The plaintiff did not address it in the lower court action, and the new arguments that are being raised for the first time on this appeal should not be considered as unpreserved. The only excuse proffered by the plaintiff for not being able to raise that argument below is that the amendment went into effect after he filed the opposition papers. But you have to look at the timeline because plaintiff filed the opposition papers on December 22nd of 2022, and the amendment went into effect on December 30th, so only 8 days after the opposition papers were filed. And this was a big deal, and according to the plaintiff, this supposedly has significant impact on this personal injury action. So
Are you saying the court could not sua sponte make this decision about a law that went into effect on December 30th?
well, the court may consider the laws that exist at the time of the decision, but what we're saying is that under party presentation principles and under the Court of Appeals decision in Misiki, a court should not.
In light of the public policy considerations and the intent of the legislature in enacting Workers' Compensation Law Section 118A, why would we do that? That would run afoul of exactly what they were trying to achieve.
Well, Your Honor,
which is to not allow workers' compensation hearing decisions other than the issue of status of employee not be deemed a issue that can have collateral estoppel effect at trials.
Well, Your Honor, what we're emphasizing on my first point is that the court generally should not be in the business of blindsiding litigants with arguments that were never raised by their adversaries, which is exactly what happened here. But
are you saying that the court did not have the right to enforce a statute that was now in effect at the time that he was considering the motion?
But even if it did, yes, Your Honor, even if it did, we still submit that the court erred in applying the statute retroactively to this action, which long precedes the effective date, because it is undisputed and it is black letter law that there's a strong presumption against retroactive application of new laws, and you need clear evidence showing that the legislature intended it to apply retroactively. And the plaintiff argues that this is a remedial.
Wasn't this statute enacted in order to right what the legislature saw as a wrong in the in court decisions that had stopped a practice that had been going on in New York State for over 80 years?
So if you look at the legislative history, which is referred to in both of our briefs, the legislature makes clear that they were responding to the Court of Appeals decision that Your Honor is referring to, the Acui case.
Yes, but the Court of Appeals decision is based on an appeal of a lower court. So obviously, lower courts were not, were giving collateral estoppel effect, and the legislature did not want them to.
Yes, and if you read the legislative history, they explicitly say that they're trying to foreclose the possibility that was left open by that Acui case, where the Court of Appeals said it may be possible to apply collateral estoppel to workers' comp decisions.
Is collateral estoppel a procedural matter or a substantive matter?
We submit that it's a substantive matter because if it's to be procedural, it has to affect the remedy, not the right. But collateral estoppel affects a party's right to relitigate the issues that have already been litigated elsewhere. It doesn't affect the remedy that is available to the plaintiff. And to Justice Higgins' point, and that is why this new law operates retroactively, contrary to what my friend argues. And to go back to the retroactivity point, there's a strong presumption, so there has to be clear evidence, but the legislative history shows that it was not intended to apply retroactively. And we also have to be mindful
Where did you find that? What in the legislative history makes you say that?
To repeat sort of what I said before.
No. Tell me what in the legislative history specifically
Yes,
makes you make that argument.
Sorry, Your Honor. Sorry. It specifically states that we are enacting this law in response to the Court of Appeals decision in Acqui, and the legislative history specifically says that we're trying to foreclose the possibility that was left open by that case, meaning the possibility that collateral estoppel may be applied to workers' comp decisions. And we also, may I, or?
Go ahead.
As we also explained in our brief, you have to be mindful of the basic canon of statutory interpretation.
Okay, no. All right, you can tell me that on
Thank you, Your Honor.
rebuttal.
Good afternoon,
Good
and may it
afternoon.
please the court. I'm Denise Rubin from Subin Associates for Plaintiff Respondent. Let me go straight to that point about retroactive. I think there's some confusion sometimes when you talk about a retroactive statute. It's not that you can't apply it to a case that began the litigation prior to the effective date of the statute, but rather whether you're going back and depriving one or the other of the litigants of a right or an obligation, or giving him an obligation that he didn't have before the effective date of the statute. That is not what 118A does. It simply says, we've noticed there's a problem here because workers' comp is only supposed to, I'm sorry, this is right in my eyes.
It's okay.
Workers' comp, the whole purpose of a workers' comp decision is to determine the level of continuing disability in terms of whether this person can go back to his profession again. It's not to determine whether he still has pain, whether he still has a torn ligament, unless it directly impacts his ability to do his job. So when we had a whole slew of workers' comp decisions saying, oh, well, he seems like he's better and he's had this surgery and now it's behind him and he's back to, in this case, status quo ante, that doesn't really work when you're talking about a summary judgment motion in Supreme Court under 3212.
Well, and at workers' comp hearings, is the standard of proof the same as in a trial in a court?
I'm sorry, Judge, not even close, and that's another problem. The standard in, for example, in Supreme Court under 3212, a judge would be abusing their discretion if they made a determination on that motion based on the credibility of one party over another, okay? Here in workers' comp, the judge expressly said, I find this doctor more credible than that doctor. And the testimony in the transcript was cut off at various points where the plaintiff's lawyer, workers' comp lawyer, tried to make some points about the way he was injured and what he told doctors when he first went for treatment, when he went for the IMEs, was cut off because the judge kept reminding him, no, we're only here to talk about the mechanism of the injury. But the mechanism of the injury was being misstated in several of these medical records, despite clear statements on the intake forms that were filled out by Mr. Nunes and an interpreter.
Well, with respect to the applicability of the statute, which is really what, our main concern here, assuming this issue is properly before us, because your friend has raised that, it seems to me there's one of three conclusions we can ultimately draw. The first is that this did not apply retroactively, but it applies because it's a case in the pipeline, so to speak. It applies retroactively, and there's no prohibition on giving it retroactive effect here. Or three, it's retroactive, but due process is offended by affording it retroactive application in this case. Is that fair, those options?
I think as far as what our three choices are, yes.
And which path would you like us to tread down?
The first path I would say is what we argued in the brief, that A, this isn't retroactive. The statute clearly doesn't say it is, and you need to have a clear statement in the statute. But even if it were, the question here is, was either the employer or Mr. Nunes given a further obligation to prove their case, or were they deprived of a right that they otherwise would have had before this statute became effective? The answer to both of those questions is no. It simply said, we are trying to avoid any more decisions by workers' comp judges on different standards that are going to be, that the plaintiffs are going to be held to later when they come in front of a jury, or in this case, a judge on summary judgment, which is what the motion was. It was a motion to amend and for summary judgment. And at that point, this record certainly, in the workers' comp hearing, certainly would not have supported a decision against the plaintiff on summary judgment. And that, again, brings us back to the whole problem that 118A was supposed to remedy. And if the court has no more questions.
Thank you. You have 1 minute on rebuttal.
Thank you, Your Honor. To address what Justice raised, this does apply retroactively. In her brief, she says a
What
statute has.
substantive right is being affected?
Yes, yes.
What substantive right is being affected?
Well,
Tell me.
Yes, the right that's being affected and being deprived of is our right to assert affirmative defense of collateral estoppel under CPLR 3018.
But again, no, you see, if a court had made that determination, then you would be deprived of a right, of a decision that had been reached by the proper standard. Here, that is not the case.
I don't see why that makes
Because the standard in workers' compensation hearings is not the same standard. They relax rules of evidence, they allow hearsay, they cut off cross-examination on issues that would be pertinent in a trial setting, et cetera.
Your Honor,
Yes.
whether a party's right is impaired, I don't think depends on whether that decision is made by a court or by the legislature. It's still affecting our right to assert the affirmative defense of collateral estoppel. I just don't see why why there's a distinction between a court making that.
I told you, the standard is different, and if I certainly shouldn't have to explain that to an attorney. That the standard of proof at a compensation hearing is much lower than the standard that would have to be met during a civil trial.
Yes, I understand.
And that therefore the parties affected here have been deprived of their day in court at the appropriate standard.
Well, Your Honor, the difference in standard, I submit, has nothing to do
Has nothing to do.
with whether a party's right is being affected by not being able to assert the defense of collateral estoppel.
That a determination was reached at a lower standard should preclude a court with a higher standard from litigating the issue. And that makes sense to you?
Well, Your Honor, I think you're talking about two different points. I think you're.
No, we're not.
Because
the standard of proof is the standard of proof. And there is no question that at a workers' comp hearing, the standard of proof is much lower than what we expect of attorneys in a civil lawsuit. And so a finding by a compensation hearing that does not adhere to the standards of the court are not entitled to collateral estoppel effect.
So, Your Honor,
and that's what the legislature said.
So I get Your Honor's distinction between the different standards of review between the two different actions. But again, I think that goes to the propriety of whether a collateral estoppel should apply. It doesn't have anything to do with whether a party's right is being affected by not being able to assert collateral estoppel. And that goes to whether a statute applies retroactively or not.
Okay, thank you. We will consider your arguments. Have a good evening.